This is an encoder check from the blue courtroom.
Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and its honorable court.
Morning, please be seated. Welcome to the Fourth Circuit. Judge Quattlebaum and I are joined today by our colleague Judge Rushing, who is in Asheville. And so I would tell the counsel in all cases, if they hear a noise from the television or they see her hand, you should stop so she can ask you a question. With that, we'll begin with United States v. Smith. Mr. Parrott.
Good morning, Your Honors, and may it please the Court. My name is Robert Parrott, and I represent the appellant, Alan Martin Smith. The police received the video in this case in a text message from a guy by the name of Randy. The video became the linchpin of the government's case against Mr. Smith. The evidentiary issue at the heart of this case is really straightforward, and it doesn't depend on the fact that we're talking about a
So
video.
did he deny that he was one of the individuals in the video?
He didn't take the stand one way or the other. He didn't dispute
There's no
it.
stipulation of fact or anything else?
Correct.
All right.
The same analysis would apply if, for instance, Randy came in off the street to the police station, and he had a ledger that he handed to the police and proved that Mr. Smith committed fraud. If the police then just accepted the ledger at face value and the government brought a case and it was shown to the jury and Mr. Smith were convicted based on that ledger, with nobody bothering to ask Randy where the ledger came from, that's the same situation that we have
Yeah,
here.
but the ledger wouldn't have his picture or his voice.
Sure. And the authentication analysis here is not about authorship. It's not about whether or not he's there. There are two issues presented here. One is whether or not the government established that it was taken on the date in question. But even if they did, there's still the issue of the production of the video. In other words, whether it was altered or edited in some material way. And the government has the burden of establishing that it hasn't been altered or edited in some material way. There were failures at three different levels here. First, the police failed to ask Randy where he got the video. Second, the government brought this case without asking law enforcement where they got the video. And finally, the district judge allowed the jury to see the video, again, without asking where this video came from. This is the federal government of the United States of America. This should be the most sophisticated justice system in the entire world, and this is what we're getting. I think it's important to note, too, that Smith is not making a confrontation clause argument here.
So, Counsel, I hear you on those points, and putting aside the alteration issue, just for the sake of this question. As Judge Agee said, we have your client in the video. You raised the point about whether when it was, and granted, that may be somewhat of an issue, but doesn't the fact that there's testimony that they're fleeing in a vehicle, doesn't the video itself, isn't it consistent with that testimony? So in terms of timing, in terms of, I think we have evidence from the overall circumstances, from which you could say, hey, this is all lining up together. This is consistent. We know it's him. We know who he's with. We know they're fleeing. So it seems like a lot of that stuff gets addressed. That doesn't completely answer your question about whether it's been altered in any way. But it seems to me, for the other issues, the nature of this evidence does a lot to authenticate it.
Well, I think that there are some consistencies between the internal patterns and characteristics of the video that are consistent with some of the other evidence presented at trial, absolutely. But there are also some aspects of the video that are inconsistent with the evidence presented at trial. For instance, the nature of the gun. The shiny silver plate with the serial number on the bottom of the gun that's not apparent in the video, I think that's inconsistent.
Actually, in certain places, you can stop the video and you see some sort of a silver rectangle on the gun, or what could appear to be it. So I don't think it's accurate to say it can't be observed at all.
Noted. I wasn't able to see it, but if Your Honor was, you're up there and I'm down here, so it's your call.
And now also there's a difference, isn't there? I mean, let's say it's unclear. You can't tell for sure if it has that silver plate or not. There's a difference, I think, in saying inconsistent and inconclusive about that. I mean, for example, he's moving it around, the lighting's different. Yeah, sure, you could say it's not as obvious there. Maybe I can't see it there. Maybe you can, but the fact that if we had a side-by-side in still motion, light down on them, one has the plate, one doesn't, that would be inconsistent. The fact that it's not as apparent, or maybe even I can't even tell for sure, Yeah, I'm not sure that makes it inconsistent. You see what I'm saying, getting at?
I do understand
Yeah,
what you're
I mean, I
saying.
think a district court, in other words, is looking at the overall circumstances, and they can say, and a district court, in an abuse of discretion sort of standard, would be able to say, hey, given all this, at least from the identity of the defendant, the timing, that much we have from the circumstances. Seems to me what you really almost have to rely on is the alteration or potential alteration.
Well, and I think that the alteration is independently an issue. And the Johns case that I discussed in the reply brief speaks to that. I mean, it's almost the same case, but the shoe is on the other foot. In that case, the defendant attempted to introduce printouts of conversations that she had with the alleged victim. And the issue that the district court had in that case was that we didn't know who printed them out. We didn't know whether they were printed in some format that allowed them to be edited. And the fact that they weren't obtained directly from America Online in that case was sufficient for the court to say, you haven't authenticated these and they need to be excluded. And so I think even if we accept that, based on some consistencies between the video and the other evidence presented at trial, even if we assume for the sake of argument that this was recorded on the date of question, that still doesn't solve the authentication problem. And in order to address, and the government makes virtually no effort to prove that it hasn't been altered or edited. In fact, the officer on the stand acknowledged that it may have been altered or edited in unknown ways. And
So what impact does it do? Keeping in mind, technology is not my long suit. But as I understand it, this is a Snapchat video, and those are short-lived, maybe in terms of a day or two or hours. How does that impact the authentication question?
well, Your Honor, first, I think that there's an assumption that this is a Snapchat video. What Officer Carter actually testified to was this resembles a Snapchat video. He had seen them before. It might be a Snapchat video. I'm not sure that that's enough to prove that it is a Snapchat video. But even if it is, in a typical case, what the government will do generally is they will subpoena Snapchat, and Snapchat will produce these videos in response. And they'll get a certificate of authenticity from the custodian of records from Snapchat, and that solves virtually all these issues because they're getting it straight from the source. For example,
So did you argue that below? Is that in your brief?
that they will typically get it from that they'll typically go
Yes.
directly to the source. I didn't mention that in the brief, no, sir.
All right.
But it is typically what they do, and I think it's a valid thing to consider when the government is pointing out that these things disappear. For instance, in United States versus Colbert, which was a case in the District of Kansas recently, the government submitted 2 preservation requests under the Stored Communications Act, which required Snapchat to preserve the records at issue. And they were able to...
Is that required? I think you make a good point that that's the best practices, and maybe and things could have been done differently here. But does that really result in a basis for saying there's not enough to authenticate this video, given the other issues we've talked about, when the officer does say that there was no alterations from the time it came to the officer? I grant you that's not pre that time. And there's no indication, maybe that's a hard thing to do, but there's no apparent evidence of alteration. Does that matter, that there's nothing that, jumps out as if, suggesting there was some alteration? Or are you saying that's just an impossible thing to detect?
It's an impossible thing to detect. I also think that it does matter that the fact that the officer said that it hadn't been altered or edited since he got...
It just doesn't go backwards, it goes forwards.
Well, I think if we go back to the example of the ledger, for instance, if Randy altered or edited the ledger, even if we assume it's Mr. Smith's ledger, if he altered or edited in some way that Mr. Smith was unable to disprove, then the government still hasn't authenticated it, right? The burden of authenticating the evidence is on the government, not Mr. Smith.
It seems that It sounds like we're kind of conflating what I think are maybe two distinct concepts. One is authentication is the thing what the government claims it is. And then another is best evidence, which is where we get to, well, is it a duplicate? Has it been altered? And in the context of best evidence, don't we put the burden on the challenger to come forward with some suggestion that there has been a change or an alteration to the duplicate?
In the concept of the best evidence rule, once the government establishes that it is a duplicate, yes, Your Honor. However, authentication by itself has two distinct aspects. One of them is, in this case, the content of the thing, right? And in this case, what we're talking about is the time when it was recorded. There are other cases where authorship is the issue, like Judge Agee pointed to. That's not the issue here. The second aspect of authentication that's important is the production of the thing. Even if a video was recorded on the date in question, was recorded by the person in question, if it's been altered or edited in some material way, and even if it's the original, Judge Rushing, even if it's not a duplicate, and the best evidence rule isn't implicated, even if we're talking about the original thing, if it's been altered or edited in some way that destroys its evidentiary value, the government still can't authenticate it.
Well, the government says this is a video of the defendant on the date in question that we got from Randy, right? Mm-hmm. And so it would seem the authentication question is, can the government make a prima facie case sufficient to go to the jury for the jury to decide if this really is a video of the defendant on the date in question that they got from Randy? And you have the officer's testimony, but you also have Mr. Pineda, the other gentleman who testified, and he testified to the content. He said, you know, the defendant told me they made a video, he made these hand gestures. You know, doesn't that go a long way towards giving the jury a basis for deciding that the video is what the government claims it is?
That speaks to the content of the video. Again, it's these exact same arguments were made in the Johns case. And in Johns, they discussed the best evidence rule, but they also discussed authentication. And the judge kept it out under both bases. And in Johns, the defendant argued, there's no question that these are emails exchanged between the victim and defendant, which is what you're saying. It's the same content-based authentication argument. And the district judge in that case said, we don't care about that. My issue is, where did it come from? You didn't get it from America Online. You got it from who knows who. And that's the same issue that we have here. And I think it's important to point out the government relies heavily on some case law saying that a missing link in the chain of custody typically goes to weight, not admissibility. Those are confrontation clause cases. Smith is not saying here that the government needs to call every single witness in the chain of custody. Some of them might need to testify. What Smith is saying is they need to at least know where the video came from. They need to at least know who's in the chain of custody. And they don't know that here. This video just came out of the sky, came out of thin air. We don't know if Randy had an axe to grind. We don't know where Randy got it from. And I think it's important that to disentangle those two issues. You know, in the authentication and context, and when we're talking about production, the burden is on the government to establish that the video hasn't been altered or edited in some material way, and they haven't done that here. I'd also like to point out that the government has argued that even if the district judge erroneously admitted the video here, that the admission of the video is harmless, and asks this court to resolve this case on harmless error review if it finds that the district court committed error, which it did. It's important to note that this court's harmlessness inquiry is not a sufficiency of the evidence test, and that's what the government argues essentially, is that there's plenty of other evidence. But the issue is whether this court can say with fair assurance that the error in admitting the video didn't sway the jury's deliberations and didn't have an impact on the outcome of the case. Video evidence is powerful. It's highly persuasive. And I don't think that the court can say here with fair assurance that the video didn't have an impact on the jury's deliberations.
All right, thank you, Mr. Parrott. You've got some rebuttal time,
Thank you, Your Honor.
and now we'll hear from Ms. Allen.
Thank you, Your Honor. Catherine Allen on behalf of the United States. The question before this court is whether the district court abused its discretion in admitting the video and finding that the government had presented prima facie evidence from which the jury could conclude that the video was filmed, the video of the defendant holding the weapon was filmed on February 22nd. And there's three categories of evidence that the government presented that satisfied that burden. The first is the content of the video itself. It shows Smith and Piper in a moving vehicle that Piper is driving. They're bragging about fleeing, and it shows them waving a black handgun, just like the black handgun that was found next to the car that they abandoned at the end of the high-speed chase on February 22nd. The second category of evidence is Smith's admissions to Pineda that he and Piper made a Snapchat video of themselves swinging around the gun and threatening people on February 22nd during the high-speed chase. And then the third category of evidence is Major Carter's testimony that he received the video on February 22nd from a repeat informant. And again, the government's not arguing that that in and of itself, that the date of receipt in and of itself establishes the date that the video was filmed, but we think that all of that evidence together satisfies the low burden of the prima facie requirement of showing that the video is what the government claimed it was.
Don't we have, I mean, isn't this the defense's position maybe becoming more and more important the more people are able to do things with videos, create videos that are false? I mean, we're in a world that seems, a far cry from what it used to be. And, with videos being created that are not authentic at all, does that factor into our analysis that we kind of turn a blind eye to the technology advances that make creation, alteration, and all sorts of things to electronic images way more possible?
Your Honor, it's true that those things are possible, and there might be cases that present interesting questions about what has been done with a particular video. But with respect to this case and this video, Smith has never contested the key aspects of the video, that it shows him holding a black handgun in a moving vehicle with Piper bragging about fleeing. And all he's done is...
What do you mean he hasn't contested? He didn't testify. So I mean, he didn't contest or concede anything about the video, right?
Sorry, Your Honor, I meant in his briefing. He hasn't even, argued. He just offers complete speculation that the video has been altered. And this is after, the question is...
He doesn't say it's been altered. He says it's a video that we don't know anything about. And it's your obligation to give the court something to show that. I don't think he's saying it has been altered. He's saying you have an obligation when you're coming in front of the court to make sure that there's more in terms of authentication than we have here.
That is his position, and I think, the question before this court, again, is whether the district court abused its discretion in determining that the government had presented prima facie evidence that the video is what the government said it is. And I think we did present that prima facie evidence, as I described earlier, and then in response, he says, but it might have been altered. The government also has a burden to show that it wasn't altered. And I think if we look at the text of the rule and what the government was required to do here, it was to present prima facie evidence that the video is what the government claimed it was. And we satisfied that burden. He elicited testimony on cross-examination from Major Carter that the video might have been altered. He argued in closing argument that the video might have been altered, that we didn't know, that the jury didn't know when it was filmed. And ultimately, these are questions...
Why didn't the government call Randy as a witness?
I'm not sure, Your Honor.
Why not get the information from the technology company where it came from? Snapchat, if that's what it was.
Again, I'm not sure, Your Honor, and Smith didn't raise a best evidence challenge below, so the government didn't have, an opportunity to present evidence that the original no longer existed at the time of trial. But as, you know, general knowledge is that the distinctive feature of Snapchat videos is that they disappear within 24 hours. And again, the
But that
government's not...
doesn't mean look, you could disprove probably lots about what I'm about to suggest, because I'm not a Snapchat expert, unlike Judge Agee. He seems to have a good bit of information about it. But even if it disappears from the phones of the senders, does that mean it disappears from Snapchat's records?
I'm not sure, Your Honor, and the
Okay.
reason we don't know is because he didn't make this argument below. So the government wasn't put to the task of introducing evidence about how Snapchat works or what files are retained and things like that.
So how would it affect your case if you didn't have Mr. Pinate, whatever his name is? If he wasn't there and available to testify, how would that affect your case?
Well, certainly we think that Pineda's testimony was strong evidence of the defendant's guilt, because Smith admitted to Pineda that he had the high point 9mm handgun on February 22nd.
Right, I understand that. That's very good evidence for the government, no doubt about that. But if that had not existed, would that change your case?
In terms of the sufficiency of the evidence or the authentication?
Both.
I don't think so, Your Honor. I mean, I think we have sufficient evidence and the video is authenticated aside from that. But again, that's not, I don't believe that Smith is arguing that Pineda's testimony should have been excluded. I think, as I mentioned at the
No,
outset.
I'm just assuming in a hypothetical that there was no Mr. Pineda. So
then-
what you've got is the major who says, I got this, I think it's a Snapchat, I got it from this guy, Randy. He's a confidential informant I've used before, and that's the video, and it shows events like we've charged. I mean, is that sufficient?
Well, I think it's a very fact-bound inquiry, Your Honor. I think in this case, because of the particular, all of the testimony about the events of February 22nd, including the fact that the jury saw the gun and could look at the video and say, that's the same gun, you know, that there was evidence that would meet the low burden of establishing the authenticity. But again, the court doesn't need to reach that here because there is Pineda's testimony. And Smith admitted to Pineda that they made the Snapchat video on February 22nd.
Doesn't that testimony just seem odd? I mean, he admitted to Pineda that he made a I mean, yeah, I guess what happens in jails is lots of things may seem odd to people who, yeah, but it, you know, it just seems remarkable that you're sitting in the jail cell and, hey, by the way, we made a Snapchat video, and it just so happens to do the authentication work that maybe we wouldn't have had the ability to do without that. And, you know, maybe that's just going to this witness's credibility as a, you know, as an informant. But anyway, I just found that testimony remarkably odd.
Your Honor, as I read the testimony, Pineda testified that Smith sort of told him the story of why he was there that day and what had happened. And the story of what had happened started with the beginning of the day when Smith was wanted for parole. I believe Pineda testified that Smith had cut his ankle bracelet off and so had called Piper, who was in his gang, so that they could hide out together. And then Pineda tells the whole story, and a lot of that information is corroborated not just by the video, but also by the testimony of the other officers. And those are some
Sure.
specific facts.
I'm sorry, go ahead. I didn't mean to cut you off.
Just some specific facts about the fact that that the gun was dropped on the other side of the fence, that the gun had one bullet in it and no magazine, and that it was the same magazine that Piper had been caught with a few weeks prior. And so a lot of the details of Pineda's testimony were corroborated by the testimony of the other officers who testified about what happened during the high-speed chase and their investigation of the case.
Your colleague, places emphasis on the Johns case. What's your position about how that case applies here and, that it helps Mr. Smith's argument?
Sure, Your Honor. So first of all, I mean, the Johns case is an unpublished decision of the Sixth Circuit. I think one of the key distinguishing features is what happened in district court. In that case, it was the district court that excluded the evidence, and so the question on appeal was whether excluding the evidence was an abuse of discretion. That's a very different posture than we have here, where the court admitted the evidence, and the question is whether that's an abuse of discretion. So it's not, Johns is not an example of a court of appeals overturning the district court's exercise of its discretion. And again, I think if you read the district court opinion, what was motivating the district court, I mean, one of the things was that the printouts that were at issue there were created likely by the defendant in preparation for trial 16 years before the trial that actually took place. And so I think, authentication is a very fact-bound inquiry, and I think the facts of this case are much different than John's, so I don't think it ultimately supports Smith here.
I'm asking this question because I don't know. How difficult, what steps would you have to go through if, for instance, in trying this case, you had sought to summons or subpoena Snapchat or whoever the internet provider was to produce either a witness or an affidavit to authenticate this particular video? Do you know what's involved to do that?
I don't, Your Honor. And again, I'm unsure whether Snapchat would even still have the files, a long time after the events the events had taken place. But again, we're not. Of course, the government could have done more in this case, and that's not the question here. The question is whether the district court abused its discretion in finding that the government had met the prima facie burden under Rule 901, and we think, for all the reasons that I've laid out and that are in our brief, that the government did.
Well, just assume for purposes of argument, we were just going to kind of skip over all that, go straight to harmless error. What's your argument on that?
Our argument on harmless error is that, Smith admitted to Pineda. There was testimony at trial that Smith admitted to holding the gun on the date in question. And that's very strong evidence. And then as I mentioned before, so that comes in the form of Pineda's testimony. And as I mentioned before, the testimony from the other officers corroborated Pineda's testimony. So we think that, an admission by the defendant is very strong evidence. And although there were credibility issues with Pineda, his testimony was corroborated by the specific facts that he told about what had happened that day, which lined up exactly with the testimony of the other officers. So our position is that even if it was improper to admit the video, it didn't substantially sway the jury in this case, and that error was harmless.
Do you have anything else for us this morning?
No, if there are no further questions, we urge the court to affirm.
Thank you.
Thank you very much. Mr. Parrott, we'll hear your rebuttal.
Thank you, Your Honor. First, I'd like to address one of the questions that Judge Quattlebaum asked about how long information is stored on Snapchat server. In United States versus Colbert, the case I mentioned earlier, in 2024 WL 209-1995, the government was able to get media from Snapchat servers 96 days after the incident in question.
That was media, that just wasn't like metadata that indicated something had been transmitted?
My recollection is that was media, but they definitely can get media as well as metadata. United States versus Herrera is another example. They got over 1,000 media files by serving a subpoena on Snapchat's server. I'd also like to point out that I'd like to correct something that the government has said in its response brief and in its argument just then. The government has characterized Randy as a repeat informant, but I think the government is playing fast and loose with the facts there. What was actually stated at trial is that Officer Carter knew Randy from previous investigations, but it's not clear whether he was an informant in those investigations or whether he was the target of those investigations. I'd also like to point out the government, when it's talking about its authentication of the production of the video, it cites several cases for the erroneous proposition that they don't have to produce evidence of when, where, or how it was created. But there's a Texas Court of Appeals case that looked at this exact issue. It's Angleton versus State, and that's referenced in the reply brief. In Angleton, although it's a state case, they did a survey of how federal courts have addressed this issue, and they found that federal courts often admit evidence without foundational proof of when, where, how, or by whom it was created, when those recordings were recovered from the defendant or a co-defendant, were not created as a result of government involvement and were not tampered with. So those are some key limitations here. The manner in which the evidence was obtained matters. In these cases, when the government can admit things without evidence of when, where, or how it was created, the government went out and affirmatively seized the evidence. And that's important because if you think about the way that a search warrant, for example, gets executed, they don't give the defendant a heads up that they're coming to search them. They do that so that the defendant doesn't destroy evidence or tamper with it. When you seize evidence from a defendant, you have some assurance that it hasn't been altered.
Sure.
Because they're not
That
expecting
would
it.
make the government's case stronger had that happened. There's a
Right.
difference in having the strongest case for which you could have and having a sufficient totality of the circumstances that this is authentic.
Well, I think that by default, the government does have to prove, if they offer the evidence as to illustrate something that happened on a particular date, I do think that the default rule is that they have to establish when it was created. And the Oriok case from this
Right.
court shows that.
And
The
they're
exception-
going, the argument is they did produce evidence about when it was created. I mean, it may not be they have someone who said, I did it on this date, but they have Panetta saying what Smith said, and they have the evidence from the video itself that shows these folks are on the run in a car when there's a lot of other evidence that they're on the run in the car. So, I mean, when it was done, you may want it to be better, but there's evidence of when it was done.
Sure, and going back to what we spoke about earlier, there are some consistencies between the other
Right.
evidence offered and here. But I think that what's important about this is there's no evidence that it wasn't tampered with.
All right.
And I think, the government mentioned the Johns case, and I think that there's an important aspect of the Johns case that we haven't discussed, which is in order to preserve an issue for appellate review, there's no requirement that the movement, incant some particular words or magic words, right? What's important is that the defendant or the person objecting puts the district court fairly on notice of the substance of the issue at a time when the district court can still address it. And Smith did that here. There's no basis to say that clearly in Johns, the government's objection was sufficient to put the district court on notice that the government was raising a best evidence rule objection. Smith did more here than the government did in Johns. So clearly, if it was enough in Johns to put that district court on notice, Smith's objection here should have been enough to put the district court on notice here of his best evidence rule objection. And notably, in Smith's motion in limine, he said, I don't know, the government won't tell us where this came from. It looks like it might be a screen recording of the original. If this is a duplicate, we're asking you to exclude it unless the government can establish that the duplicate accurately reflects the original. That's the essence of the best evidence rule right there. So Smith raised this issue, and then when the district court admitted the video over Smith's objection, it gave no analysis whatsoever. It just said overruled. It didn't give any authentication analysis. It didn't give any best evidence analysis.
All right, you got anything else this morning, Mr. Parrott?
No, Your Honor. Thank you.
All right. The court notes that you are court-appointed, and we want to extend our sincere appreciation to you for undertaking representation. In this case, we could not discharge our duties unless members of the bar like you stepped up and undertook to do these tasks. So with that, we'll come down and greet counsel and move on to our next case. All right, our next case is Washington versus the Federal Bureau of Prisons. Ms. Arfa, did I pronounce that correctly? We'll hear from you.
Judge Agee, and may it please the court, Leslie Arfa of Sullivan and Cromwell for Appellant Borough, Washington. While the record in this case is relatively lengthy, the remaining issues in dispute are actually quite narrow. Mr. Washington suffers from glaucoma and has been in BOP's care for nearly 2 decades. During that time, his eyesight has gone from meaningful to practically non-existent. There's no dispute that multiple ophthalmologists recommended surgery on Mr. Washington's left eye, and that Mr. Washington did not receive that surgery or even a follow-up appointment for nearly 9 months. There's also no dispute that no fewer than 4 ophthalmologists recommended that he receive assistance administering his eye drops. Yet BOP overrode those specialists' instructions as well. It's finally undisputed that Mr. Washington's eyesight deteriorated in the meantime and that his eye pain increased. BOP tries to disturb the chain of causation here by pointing to Mr. Washington's purported incidents of noncompliance. But it's blame the victim
Well,
strategy.
doesn't this really come down to you've got a battle of medical experts, which, we see that all the time, and the district court credited one more than the other. There's some evidence in the record to back that up. Why isn't that the end of it?
So we don't think this is the typical battle of the experts, Judge Agee, and that's for a couple of reasons. On both breach and causation, the district court made legal determinations, and we believe those determinations were in error. And let's start with breach. The district court credited the government's expert, Dr. Ulrich, over Mr. Washington's expert, Dr. Kotecha, because Dr. Kotecha didn't have expertise in administrating medicine in the prison setting, and she couldn't point to the specific medical provider within BOP who was responsible for withholding care. And that doesn't work for a couple reasons. The first is that they weren't testifying about administration in the prison setting, and there was actually no dispute on this record about who was responsible for scheduling the care. That was Dr. Laurent at FCI Williamsburg. So it really wasn't in dispute, and you can imagine why you wouldn't want to impose that requirement on a plaintiff in an FTCA case, because they would almost always need to find either a BOP employee or a former BOP employee to testify. They weren't admitted to testify about the prison administration, and so it was legally incorrect to fault her for that reason on breach. And once we get
I
past...
thought Dr. Ulrich testified to the effect of, even if all these factual events occurred, that still did not establish to a reasonable degree of medical certainty that the Bureau of Prisons' decisions made any difference.
That's also correct, Judge Agee, but the reason he made that determination, and that goes to the second error, which is on causation, is that he found, as a matter of modern medicine, it's just not practical to determine causation when it comes to advanced glaucoma. And that didn't work for several reasons. The first is it contradicted his own testimony. He testified that lack of treatment always causes glaucoma to increase, and he didn't say over any period of time. He said always causes glaucoma to decrease as long as there's lack of treatment. And the district court didn't say why she was overturning the recommendations of not only Dr. Kotecha, but also the other experts in the record, who said that absent medical care, deterioration of vision will occur. And those experts were doing what Dr. Ulrich said was impossible to do, which was to attribute causation when it comes to glaucoma. The truth is that glaucoma is no different than any other disease, and the cases we
The only two
cite...
experts you had here were Ulrich and the plaintiff's medical expert. Is that right?
Ulrich is the government's medical
Right.
expert, and plaintiff's medical expert was Dr. Kotecha.
And so those are your only two experts. None of these other doctors testified.
They did not testify, but their recommendations were in the record, Judge Agee. And again, they all did what Dr. Ulrich said was impossible. And I will say, we cited on page 12 of our reply several instances where courts didn't have any trouble finding causation when it comes to advanced glaucoma. And that's because glaucoma is no different than any other progressive disease. It might be difficult.
Your counsel, that argument, you're characterizing it as a legal error. and I wonder if that's right. I mean, the doctor said he didn't think causation was established. There's testimony about, how his eyesight was from the time he got there. There's testimony about his compliance or lack of compliance. There's all this stuff over this time period that are potential events that would cause, number one, the disease to progress naturally. Number two, his non-compliance. And number three, the fact that even these surgical interventions, aren't necessarily, it can't be effective and can make things worse. And given all that in the record, I get there's very, different testimony on the other side. So I certainly understand that. But given that, I'm just having trouble how we would say, as a matter of law, a district court erred, at least on the causation side.
Sure, so a few points in there that I want to tease out, Judge Quattlebaum. The first is that I don't think it's a fair representation of the record to say that Dr. Ulrich made a factual and not a legal determination, and that the district court made a legal determination there as well. Because what Dr. Ulrich testified was that, quote, as a matter of modern medicine, when it comes to advanced glaucoma, it's just too difficult to determine causation. That really wasn't based on the specifics of the facts here or the plaintiff's glaucoma. Now, when it comes to the noncompliance, he did.
So what? So he says that, you disagree with it, there's evidence on the other side. Why is that wrong for a district court to say, I think that has some appeal to me?
Well, because what the district court said was not, on this record, it's impossible to determine causation when it comes to advanced glaucoma, but due to the advanced nature of glaucoma and how it progresses, it's impossible to determine causation. It would be as if, to take a different example, if the judge found it's just impossible to determine causation when it comes to heart disease, there's no way to find medical malpractice when it comes to some sort of heart surgery. We do think that that is an error of law. But I do want to turn to the noncompliance, because I think that's critical here on this record. We think we can put the noncompliance in two different buckets. And in one bucket are instances that just can't qualify as noncompliance at all. And the best example of that is the only example the government can come up with during the relevant period when he was being withheld surgery on his left eye. And that's at page 22 of the government's brief. They cite to JA 82. But if you look at what the government's citing, it's a nurse's note where the nurse observes that Mr. Washington accidentally, and the key word there is accidentally, misuses his eye drops because he can't see. And the reason that's critical, Judge Quattlebaum, is because that's the only incident of
I
noncompliance.
thought there was evidence in the record that he would just take his medicine and squirt it out and come back to them and want more, or that if his favorite nurse wasn't there to put the eye drops in, he wouldn't do it, and that they had had a long period of observation in the different facilities where he could put the drops in, he just wasn't going to do it.
Right, so I think the timeline here is critical, Judge Agee. When it comes to the period from August 2014 to May 2015, and that's the relevant period when he was being withheld surgery on his left eye, there actually weren't those incidents of squirting out bottles, et cetera, that the government points to later down the road. Now, obviously, we disputed at trial whether he was really misusing his medication, but at a minimum, when it comes to causation, if there aren't incidents of noncompliance during that nearly 9-month period when he was being withheld surgery, it's impossible to say that the government has carried its burden establishing contributory negligence. That is, that he was over 50% responsible for the deterioration in his eyesight. And if they can't establish contributory negligence, then noncompliance would detract from his damages, but it wouldn't go against liability. Now, yes, there are incidents after 2015, so that's after the relevant period when it comes to the surgery, when BOP documented incidents of noncompliance. And of course, at trial, we did dispute whether that was noncompliance. But I do think you have to put those incidents in context, Judge Agee. We're talking about someone who's been withheld medical care for years, whose eyesight
This is all a factual argument, right? So the district court held a trial and made findings of fact, right? So I don't want to stop your argument, but I'd like for you to maybe focus on how you can meet your heavy burden to overcome the trial court's factual findings that, that the plaintiff was more negligent than the BOP here. I mean, how are we in a position to disagree with that weighing of the negligence?
Right, so we take the point on the standard of review here, Judge Rushing, but we do think the district court made legal conclusions when it was arriving at that decision. And it starts with the conclusion.
When it comes to comparative negligence, what's the legal conclusion what's the legal error that would get victory for you on comparative negligence?
So on comparative negligence, we do think that underlying that decision were some of her findings about how causation is impossible to determine when it comes to advanced glaucoma. And I will say this, the comparative negligence finding was really a throwaway finding at the end of her decision, and and the reason the government is focusing on it on appeal is because comparative negligence would only go to damages and not liability. But I think whatever the standard you're applying, Judge Rushing, we don't think it matters, because when we look at the surgery, if there are no incidents of noncompliance during the relevant period, it can't possibly be that the government carried its burden of establishing comparative negligence. How could it be that it carried its burden of establishing that he was more than 50% responsible for his decline in vision if he didn't do anything to delay the surgery? And that's what
Why are we looking at this artificial period? I mean, if the question is who's more responsible for the decline in his vision, it seems like we would be looking at the whole period in question, not just, how much evidence is there of his negligence during the months when the surgery was delayed. I mean, why are we just looking at that period?
Right, I take the point about timing, Judge Rushing. I think the reason we're starting the relevant period in August 2014 is because that's when the surgery was recommended, and there's no dispute on the record that that's the case. And we know that for 9 months, he didn't receive any care, and his vision deteriorated.
Right,
and
but that doesn't really answer the question I think Judge Rushing asked, which is why aren't we looking at the whole period?
Well, I think the law is clear on this, Judge Agee, and we discuss it in our briefs, that noncompliance outside the relevant period doesn't absolve BOP for withholding medical care during the relevant period. And that makes sense at a high level, because just because someone's noncompliant in one time, it doesn't surrender their right to care for the rest of their lives, just as it's true.
So
It's not.
is your argument that there was no evidence of noncompliance prior to this period?
There was some evidence of noncompliance prior to this period, and that gets to my point, and there was only one that the government points to in its brief, but the point is that, and the Lister case from South Carolina bears this out, just because a plaintiff denies care at one time or is noncompliant doesn't surrender his right to care going forward, and the same is true, if not doubly so.
Well, he wouldn't surrender it, but it's not a fact that you can ignore.
Well, actually, this court said as much in the Smith case that noncompliance outside the relevant period, you can't infer noncompliance during the relevant period just based on noncompliance alone. And there, the relevant period was only 2 weeks long, and the noncompliance happened shortly thereafter. So I think this court has already said as much, and we're on even stronger footing than the plaintiff in Smith, because there, the government, it was at the pleading stage. The government was free at trial to put in evidence of noncompliance during the relevant period if it wanted to. Here, the government spent the entire trial putting in evidence of noncompliance, but it couldn't put in evidence during the relevant period when it comes to the surgery. And
So far, you've addressed your Tort Claims Act claim. Do you want to move on to the reasonable accommodation parts before your time expires?
Sure, I would love to, Judge Agee. Yeah, I think the district court's errors here were clear. And just going back to the standard of review and Judge Rushing's question, we do agree that most of these errors are reviewed under the clear error standard, but that standard is not toothless. And here we think the errors are apparent from the record. That's most obvious when it comes to the braille and the lock. The district court found that there was no substantive evidence that Mr. Washington was interested in learning braille.
I know you're trying to get it in. Could you say that again a little
The
more
district
slowly?
court found that, sorry, Judge Guadalajara. The
That's
district
okay.
court found that Mr. Washington, there was no substantive evidence that Mr. Washington was interested in learning braille.
Said little or no.
But the record, little or no, but the record is clear that he had requested it no fewer than 4 times. And that's in 2014, 2015, and 2016. And remember, he filed suit in 2016. So we really don't know what we're arguing with the government on this point. He's entitled to this accommodation. The government provides it as a matter of ordinary course, and he's pursuing this lawsuit for 8 years to get it. Clearly, there's evidence in the record, and more than just a little, that he
I
wants
thought
to
the
learn
district
Braille.
court said something to the effect there was no evidence that he currently wanted Braille. Not that that's necessarily relevant, but that,
Right, and we don't think that's the right framework to look at this, because it seems like what the government is arguing today is that he had an obligation to update the court as the trial went on about his interest in Braille beyond his testimony. We don't think that can be the right standard in the Rehabilitation Act
That's
context.
fair, but the district court also said when he was presented with the opportunity to get Braille, he refused to do what was necessary to, when the request was granted, there were paperwork requirements, and he wouldn't fill those out. So I think that was part, it wasn't just that you have a duty to keep updating me of your request. It's, you may have made some requests, we granted one when, there's a dispute about whether it was requested after that. Someone says yes, someone says no, but the time where it's granted, Mr. Washington did not do what was necessary from a paperwork standpoint.
Right, so there was a hearsay testimony from Dr. Ulrich that he had declined to sign a form in 2017 that offered him Braille.
Why is that hearsay?
Well, because he had no direct knowledge of it. And we don't know what he was referring to when he said that. There was no evidence in the record of the 2017 incident.
Is it admission by a party?
Well, I don't think it would qualify as an admission, but regardless of what you think of the
Yeah,
hearsay
right,
rules, and
right.
I'm sure we could debate those for a while, there was this oblique reference, but we don't think the fact that he was offered it once apparently, although he continues to dispute that, would forever surrender his right to it. I think the other thing I'll say quickly, and I know I'm over time, is that the errors were
why
also...
don't you give us a quick 1 minute on the glasses and the security lock?
Sure, so I think that the lock on, the error on the lock was even more apparent. The district court found that BOP had a valid security reason for denying the lock, but BOP had never offered a security rationale, let alone justified it. And remember, the relative comparator here isn't whether it would be dangerous or pose a security concern to give an inmate a lock. The district court conceded at footnote 21 of her opinion that all inmates are given a lock as standard issue. The question would be whether giving Mr. Washington a lock that's modified so that he could use it would pose a security concern. There's just no evidence in the record that it would. The government tries to come up with one in its brief that it somehow would be a security concern for him to be able to keep his medicine, but it's just not plausible, and it's not the reason that they gave below.
And that, on that point, we perhaps could look at the record if there was another reason that would support that, but is there any other evidence in the record with respect to the lock? I didn't see.
No, there really is not, Judge Quattlebaum. There's vague references to discretionary authority, but there's no specifics about why BOP exercised that discretionary authority here.
All right, very quickly, tell us about the glasses.
Sure, so quickly on the glasses, there's no dispute that it was prescribed by a specialist, these tint number 4 glasses, because it would help him walk around the prison without feeling pain. The district court deferred to BOP's policy against providing these glasses, but at a high level, that doesn't work because almost every
I
plaintiff...
thought there was evidence that they did that because they thought the heavier tint was a tripping risk.
There is evidence of that, although the government also said that there's no meaningful difference between tint number 3 and tint number 4. We just don't see how it could both cause a tripping risk and there be no meaningful difference. But taking that aside, we're again taking the specialist's word for it here, that it would cause a meaningful increase in his ability to navigate the prison. And remember, all we're asking for is a meaningful, reasonable accommodation. The BOP already provides tint number 3. It's never explained why it would be some sort of undue hardship to present tint number 4. He's asking for the most basic accommodations here.
All right, I think we've given you a lot of extra time,
Yeah.
but you've got some rebuttal time.
Thanks, Judge.
Mr. White?
Thank you, Your Honor, and may it please the court. Graham White for the Bureau of Prisons. The district court correctly found that BOP made extensive efforts to both treat and accommodate plaintiff's glaucoma throughout his time in BOP custody, but that they were thwarted at every turn by plaintiff's self-sabotaging behavior. As the district court made clear in more than 160 pages of comprehensive factual findings, plaintiff consistently and intentionally refused to take his prescribed glaucoma medications. He was abusive towards BOP medical staff and towards other inmates who were assigned to assist him with his disability, and he refused to consent to multiple recommended surgeries that his outside medical providers had recommended. Now, I'll just start with this purported period of noncompliance with the eye drop medications and whether that happened during the 9-month period or outside of it. What the district court found, and I'm quoting directly from the district court's opinion, is that the plaintiff was, quote, serially non-compliant with his eye drop medications during this August 2014 to May 2015 period.
What's the evidence in the record that supports that finding?
Yes, so the district court cited a BOP medical record showing that the plaintiff consistently ran out of his eye drops every month, showing that he was not taking them as directed.
Do those records reflect that 9-month period?
Yes, it was during the 9-month period. So you have that record showing that he was running out like way too early, that if he had been taking the medication as directed, that wouldn't have happened. But even apart from that, there is overwhelming evidence that he was non-compliant with the medications both before and after that period, which I think is probative of his behavior during that time.
So what's your best evidence that he was non-compliant before that period?
Well, I think before the period, there were multiple surgeries, for example, where he refused to attend his postoperative care. I think, let me emphasize, I think the concern here is more with there's more substantive evidence with respect to the period after May 2015. And just to give you, Your Honor, one example, I think during the period from 2015 to 2017, when he was at FCI Estill, according to one BOP medical record, he affirmatively refused his eye drop medications the majority of the time that they were prescribed to him. There were between roughly 70 and 80 affirmative refusals to take the medication just during a 2-year period, all right? So there is plenty of evidence showing that he wasn't taking the medication as prescribed, and as the district court found, he knew how to self-administer the medications, all right? He was seen by BOP staff self-administering the medications on numerous occasions. He would show BOP staff that he could do it, and then he simply wouldn't do it. And then let me also speak.
Counsel, can I ask, I'm sorry to interrupt you, but I want to get your response to the argument that the district court committed legal error by crediting an expert who said that it was medically impossible to determine causation in this situation. Do you have a response to that?
I think what the district court is saying is that, well, first of all, I think these are factual determinations that the district court is making. This is a classic battle of the experts here. But with respect to determining causation, the district court is saying, in crediting the government's expert in doing so, that when you have a patient with end-stage glaucoma, it's very difficult to attribute any worsening of a plaintiff's vision and increase in pain to a lack of surgical intervention. And there is ample evidence in the record to support that. To take a couple of examples, in the time period right around where the plaintiff's outside provider, Dr. Natitis, had recommended this laser diode surgery, immediately before that, the plaintiff was seen by other outside ophthalmologists who recommended against surgery on the ground that, look, this is going to do more harm than good. And that was borne out, in fact, by plaintiff's history, where he had underwent another surgery on his right eye in 2012, I believe, that was unsuccessful, and underwent another cataract surgery in July 2014 that was not successful. So it is not at all clear from the record that had plaintiff undergone this surgery in May 2015 that he's challenging, that this would have made any difference at all. And I'd like to also just provide a little bit of context, if I could, around the recommendation and why it was not ultimately followed until May 2015. So at the time that Dr. Natitis is making this recommendation in favor of a surgery in August 2014, the plaintiff had just undergone another surgery by the same provider a month earlier that did not go well. The surgery was not successful on its own merits, but also because the plaintiff was exacerbating the problems by not attending his postoperative care. And that was not the first time that this had happened.
That was on a different eye than
Different eye.
the other. Okay.
Different eye, but by the same surgeon who's recommending this additional surgery. And that comes on the heels of another surgery in 2012 where plaintiff also underwent cataract surgery on his right eye that was not successful. And again, plaintiff was making things worse by not attending the postoperative appointments. So ultimately, when BOP is making a decision on whether to approve a surgery that is recommended by an outside provider, it involves a cost-benefit analysis where BOP has to consider what is in the prisoner's best interest here. And what the record shows is that these surgeries have a very low success rate when you're talking about end-stage glaucoma, and the plaintiff is not helping his case by, not only refusing to take the medications, but also not attending the postoperative care.
Was there testimony that the 9-month delay was because of that? Because he did not carry out his self-care with that prior surgery? I recall the testimony or the evidence that there was that prior surgery. I recall the evidence that he didn't do what he was supposed to do afterwards. Was there testimony that the reason it was not scheduled was because of that?
Yeah, so Daniel Whitehurst.
This was Whitehurst?
Yeah, Mr. Whitehurst, who was on the medical staff at FCI Williamsburg during the relevant time period, explained that the plaintiff's, again, noncompliance was a factor in this decision. And apart from that, we had the government's expert witness, Dr. Ulrich, who was explaining that BOP officials have to have some latitude in deciding whether to approve a recommendation from an outside provider. It's not the case that—
Did he limit his opinion to prior, the nonconformance prior to this 8 or 9 month gap?
Did Dr. Ulrich? I'm sorry.
Whoever you were just, the
Yeah.
expert you were, whoever you just identified.
Yeah, so when Dr. Ulrich was making this opinion, he was basing it not just on the August 2014 recommendation, but also the recommendations from other outside ophthalmologists in 2013 who had examined the plaintiff and said, we need to, quote, stop fiddling around with his eye because we're going to make things worse. And that partially formed the basis of Dr. Ulrich's conclusion as well. Unless the court has any— well, let me also just say, before I move on to something else here, that we, at some level, the time in which the surgery was ultimately scheduled is a little bit beside the point because the plaintiff refused to have the surgery when it was provided to him. He went to the surgery after it was approved. He was attempting to leverage—
This was in 2015.
This was in 2015. When he arrived at the outside clinic to get the surgery done, he was attempting to coerce the outside provider to prescribe him certain medications. The provider refused to do it, and the surgery didn't happen. And remember, these are the providers—
What's the point of that looking backwards?
Well, I think it just shows that with respect to causation, we don't know whether this surgery would have made any difference if it had gone through, because it just didn't happen in May 2015. And then one other point is that, so this surgery didn't go forward in May 2015 because of the plaintiff's own actions. It ultimately didn't happen until 2017. And I know that the plaintiff isn't challenging that delay that followed, and so we don't really get into our briefs, but I think it's important context for the court to understand. The reason there was a delay of about 1.5 years after that is because the plaintiff refused to see an ophthalmologist for another year after that. All right, so there is ample evidence in the record to support the district court's finding that the plaintiff's own action here are primarily responsible for his deteriorating vision and increased ocular pain. Now, with respect to whether he needed assistance with his eye drops, I'll just reiterate that the district court found that the plaintiff, again, did not need assistance. He was seen administering the eye drops on his own without help, and even if he did, BOP provided him with relevant assistance at every facility in which he was housed. They would place him on the pill line where he could go and have BOP staff administer the eye drops for him. A lot of the times he just simply wouldn't go to have the eye drops administered, and BOP also offered him devices, like an auto drop device that would assist him with administering the eye drops. He refused to accept it and threatened to smash it on the ground. So again, BOP is trying to bend over backwards to accommodate the plaintiff's condition here and are just being thwarted by the plaintiff's own self-sabotaging behavior.
What's the evidence in the record that supports the district court's decision to deny the accommodation of an alternative lock for security reasons?
Sure. So here's what's in the record on that. So we put forward 2 witnesses below. We have Lieutenant Kaminsky, who was the occupational therapist, and Carl Luckfeld, who was the administrator for the Special Populations Branch. Both of those witnesses testified at trial that an accommodation like this is up to the discretion of security personnel, and that it was not, and that they exercised that discretion to deny the request. That's at JA 181 and JA 193.
So how does that relate to whether or not it's a reasonable accommodation?
Well, I think for a couple of reasons. In terms of whether it's a reason, let me say a couple of things in response to that.
Well, let me go back.
Sure.
If you look at it and compare it to the tinted glasses. There is an explanation in the record as to why this wouldn't work, why it wouldn't be a reasonable accommodation, because it would make him trip. Maybe it would, maybe it wouldn't. But there was an explanation for that. But here, all we have is, well, it's discretionary for security purposes, but it doesn't really explain why there can't be a reasonable accommodation, notwithstanding that policy.
Because there is evidence in the record showing that plaintiff abused his locker by hoarding medications. And just to be clear, this was not just him hoarding his eye drop medications. The district court found, and quoting again, this is at JA 143, that the plaintiff was hoarding, quote, hundreds of pills of many different drug classes, most of which were prescription medications, all right? It's not that big of a leap to say that one form of contraband in a locker could lead to another. So we have these two witnesses, Lieutenant Kaminsky and Carr, who are saying that this was denied pursuant to security reasons. There's evidence in the record to substantiate that he was hoarding his medications in his locker, and this is an area where judicial
Well,
deference
couldn't they have, if they gave him whatever this alternative lock is, I mean, couldn't they have entered the locker at any time, just like they could with any other inmate's lock?
Yeah, so I'm happy to answer that, but I just want to preface this by saying that this explanation is not in the record. But my understanding from talking to BOP about this is that the standard issue inmate combinations have a master key that BOP staff can go and open at any time at the officer's discretion. The alternate vision impaired locks don't have that feature. And so even if BOP were to write down the combination, the inmate could change it at any time. So look, correctional officers could ultimately take, I suppose, a bolt cutter and force open the lock, but that's not something that they could do quickly. And so I think in this particular case, correctional officers have an interest in being able to quickly search contraband, especially when we have an inmate like the plaintiff who is not only hoarding medications, he has a history of disciplinary infractions that have landed him in the special housing unit on multiple occasions. So I think this is an area where the decision of BOP officials to deny the lock is very reasonable, and there's evidence in the record to support that.
Wasn't there, just to refresh my memory, I thought there was testimony that some inmates are given these alternate locks, so in some cases it is a reasonable accommodation?
Yeah, so I think it depends on the circumstances surrounding the particular inmate who's requesting it.
Right, so the justification is for this particular inmate, that he poses a particular risk that other inmates don't?
Yes, and that is supported by the record.
And
again.
where was that justification given by BOP to the district court?
Well, what we have in the record is that, again, we have the two witnesses, Kaminsky and Luckfeld, who said this is up to the discretion, it was denied, and there is evidence in the record to support why that would be the case, again, because of hoarding medications. Like, we didn't think there's a need to say more than that because I think it doesn't require a lot of guesswork as
Well,
to
did
why
those two witnesses say that the hoarding of the medicine was the security reason?
They did. There was no elaboration as to what the security reason was, but there is. This court can affirm for any reason that is apparent in the record, and the record makes clear that this inmate posed some security risks because he was, again, hoarding contraband and had a long disciplinary history. Unless there are any further questions of the lock, I'll just quickly touch on the Braille and the tinted glasses. With respect to the Braille, as we argue in our brief, there's no live controversy here. The last time that the plaintiff requested Braille was in 2017. BOP provided him the Braille, and he refused to come and sign the paperwork to get it. He hasn't requested Braille since then. We're happy to give it to him. There's no issue with that. But as the district court found, there is no current request for Braille, and so that does not entitle the plaintiff to obtain any declaratory injunctive relief. The entire basis of the plaintiff's claim for Braille here is that he was purportedly denied the Braille materials in 2014 and 2015, and that is not enough to show a live controversy. And finally, with respect to the tinted glasses, the Rehabilitation Act requires reasonable accommodations. He requested tint number 4, he got tint number 3. We don't even know the extent to which tint number 3 would have been effective because plaintiff refused to use the tint number 3 glasses. And beyond that, the last thing I would say on the glasses is that a plaintiff is only entitled to relief under the Rehabilitation Act if they show that they were if they were denied meaningful access to prison services because of being rejected in accommodation. And there is no evidence in the record to show that the tint difference here had any impact on the plaintiff's ability to access prison services. So unless the court has any questions, we would just ask the court to affirm.
All right. Thank you very much. Appreciate it. Ms. Arfa, you've got some rebuttal time.
Thanks, Judge Agee, and I'll just make a few points here since I know I went over the first time. The first thing I'd just like to clear up quickly is this issue about evidence of noncompliance during the relevant period from August 2014 to May 2015. Again, there really isn't any. The government can only point to the pharmacist note and the nurse's note observing a J83 that he sometimes runs out of medication because he struggles to apply it. And that's really at the heart of our FTCA claim for assistance with the eye drops and our Rehabilitation Act claim for assistance with the eye drops. So just wanted to clarify the record here. And thus, it was a legal error to conclude that noncompliance would detract from liability during that 9-month period. A couple of the arguments the government's raising now are new arguments, and they just aren't in the record below. There's now a new argument that actually he didn't need the surgery at all because in 2013, a specialist had recommended against it. Now, again, we're talking a year earlier about a progressive disease like glaucoma, but even there, the record is clear that actually 2 different specialists thought he needed the surgery then. But whatever you think about what happened in 2013.
I understood that argument. Maybe I misunderstood it, and please correct me, but I thought I understood that argument related to causation, that it's hard to determine his current condition was caused by the lack of surgery because some people say, hey, surgery may not help and may make things worse. Maybe I got that wrong, but I thought it was more of a causation than they were saying he didn't need it at all.
Understood, but I think first it's misleading to say that experts didn't think he needed it in 2013 when several did. Now, on the causation point, BOP says now that the surgery has a low success rate. That's not in evidence. That wasn't testified to at trial. But we also know that any surgery doesn't have to have 100% a guarantee of success to succeed. Dr. Kotecha testified that this gap in care caused his eyesight to decrease, and Dr. Ulrich, the government's expert, also testified that lack of care always causes vision to decrease. Now, on the Rehabilitation Act claims, with regards to the lock, we're just way outside the record now, and we're trying to come up with reasons for why BOP declined the lock. But BOP didn't testify never offered evidence as to why it declined the lock beyond alluding to a vague discretionary reason.
But why I think you're right. Your colleague conceded he was given the details of how the locks work, and that wasn't in the record. Mm-hmm. But there is a finding that the lock was not granted. The request was not granted because of security reasons, and the witnesses didn't attribute that to his hoarding of medication. Mm-hmm. But if they didn't, but the record indicates he does do that, just assume the record indicates he hoards that medication, can we not use that as an alternative basis in the record to support that finding?
Sure. So it wouldn't be a factual finding the district court made that you'd be reviewing for clear error. So you'd be looking at the weight of the evidence here, and you'd have one vague allusion to a security concern relating to hoarding medication. We don't really see how that would be a security concern. If anything, it might be a medical concern. The only security concern here goes the other way, and that's the evidence is clear that Mr. Washington's cellmate was putting knives in his locker as a threat, and Mr. Washington was unable to lock him out because he couldn't use his lock. When we talk about Lieutenant Commander Kaminsky's testimony, all he said at J1124 was that the standard issue lock is very hard to see, but that we denied this lock for a discretionary reason, not security and not related to hoarding the medicine. We just think it's not plausible to say that BOP has carried its burden of establishing an undue hardship in providing him this lock when they provide everyone else a lock. And on the Braille, the evidence is clear too. Again, the government's contriving a new legal requirement that when someone's making a Rehabilitation Act claim, they have to keep coming forward with more and more live requests as the case proceeds and as you go to trial.
Well, the government says the record shows that Mr. Washington did request Braille. They offered it to him, and he refused.
Again, we really don't think the record is clear, and that's certainly not a basis that district court rules. But again, offering it one time in 2017, they've continued to deny it. This lawsuit's gone on from 2016 to 2024.
Right,
the
but
government's
what's
still
the
standing here
evidence that
saying,
since he refused it in an earlier time, that he's asked for it again?
well, again, we don't think he refused it. The best the government can come up to is vague testimony that he couldn't sign a form because he didn't have an inmate companion. He he had no idea, and he testified at trial, that he'd ever been offered Braille. But he's continued to pursue it to this day, and the government still
Well,
says.
how has he continued to pursue it other than through the lawsuit?
Well, since we're going outside the record, he has continued to.
Well, is there anything in the record that shows that he has pursued a request for Braille since arguably the record shows he refused it at an earlier time,
Well,
other than his complaint?
Well, there's his testimony on the subject, but there's also the fact that we're looking at the timing here. He requested it 4 times from 2013 to 2015, then filed suit in 2016. And remember, all we're asking for is injunctive relief here, Judge Agee. He wants it, he's been pursuing it for 8 years, and we're just asking the government to provide it, which they do to inmates all the time. We're not asking them to transform this prison system for him. And just quickly, on the glasses, we think it was.
Look, I don't want to belabor this, but the government just said, if he asks for it, we'll give it to him.
Well, then if
But
that.
apparently he hadn't asked for it since 2016.
Well, they're not quite saying that if he asks for it, he'll give it to him, because he's asking for it through this lawsuit, and they're not conceding error. They're not saying, we'll give it to him right now, and we're going to moot this case out because we're conceding error here. They're not saying that at all. They're standing up here and saying he doesn't deserve that accommodation because he apparently doesn't want it. And I think that's a very different argument, Judge Agee.
All right. You got anything else for us?
Just quickly on the eye drops, BOP says the difference isn't meaningful, but also it made him fall over, and the specialist's recommendation at JA 498 contradicts that. With that, I thank the court for the considerable time it gave to this and the questions. Thank you.
All right. We thank both counsel for their arguments. We're going to come down and greet counsel and take a very brief recess. please be seated, and we'll hear argument in our next case, OW versus Marie Carr. Ms. Gaines?
All right. Your Honors, may it please the Court, my name is Makiba Gaines and I represent the appellant OW. OW is on appeal from an award of summary judgment to the appellees in the district court and denial of partial summary judgment to OW. Today, without waiver of any issues, I will explain why the court should reverse or vacate the judgment of the district court. Your Honors, since TLO was decided in 1985, we know educators need only reasonable grounds to search a student suspected of committing violations of school rules or the criminal law. But the court told us in TLO that this rule would not apply as a special needs case where educators shown to be coordinating with or acting on behalf of the police. In 2008, the Virginia Beach Police Department and the school board, they entered into partnership, the SRO partnership, and they split that process. They agreed that going forward, the educators would investigate students for violations of school rules, and their partners in the police department would investigate the violations of criminal law. But since that time, educators have continued detaining, searching, and interrogating students while their police partners are present in a manner that avoids all the burdens of direct police action and deprives children of procedural safeguards that would be afforded to adults in the same situation.
So are you alleging some sort of a conspiracy here? I'm not exactly sure where you're going.
Not necessarily arising out of just a partnership agreement, Your Honor, but their conduct as well. But yes, there is an allegation of conspiracy between the separate parties, Your Honor. On March 5th, 2019, pursuant to that practice and custom, OW and 2 other students were detained.
So what's your, other than this agreement, what's your evidence of practice and custom?
Well, Your Honor, Officer Carr testified that it was a part of her policy or her custom that she would only get involved when the investigation involved criminal conduct. However, I'm sorry, just a moment, Your Honor. SRO Carr's supervisor, Arnold, testified that this investigative practice has always been the case since he's been employed in the Virginia Beach Police Department. And so 20 years of similar investigations conducted the same way is certainly proof of a tacit understanding. We also have communication between Officer Carr and Mr. Baker. The female student testified that Mr. Baker would leave the room with her from time to time to have communications or conversations with Officer Carr.
But counsel, at least on the Fourth Amendment claim, if TLO and Walford apply, isn't the test about whether you can, do a search, conduct a search, isn't the test reasonable suspicion?
Well, the test would not be reasonable suspicion, Your Honor. And the reason the test is not reasonable suspicion is because on school grounds, we're talking about the special needs exception or the special needs doctrine, whereas Wofford pertained to the exigent circumstances exception. And so that's where the court went wrong. The court extended the special needs doctrine directly to law enforcement through the exigent circumstances exception. In United States versus Curry, this court clearly delineated.
Can I pause you there? You said the court extended the TLO standard to law enforcement. I thought the search you're challenging on appeal is the search by the principal, not the search by law enforcement.
Yes, Your Honor. The court stated that the special needs doctrine, of course, covers, or TLO covers the office or Mr. Baker's search, but the court also stated that it covered the principal's subsequent search as a part of this Wofford exception, which is an exigent circumstances case.
And the question on appeal, right, is the principal's search of the phone.
Yes, Your Honor, that's a part of the issue on appeal. We're asking the court to also remand and answer the question, for the district court to answer the question in regard to the officer search as well.
And what's the question?
Where's that?
What's the question you want remanded?
Well, the court did not answer the question about whether there was a conspiracy between the parties and whether Officer Carr's search was unlawful. We were asking the court to consider the question of conspiracy and determine whether Officer Carr's search is
Okay, and your
also
evidence of
unlawful.
conspiracy is there's this cooperation agreement between the school board and the police department, and what else?
Well, Your Honor, it's also how they have used the agreement between the two separate parties. It's the fact that the way the process works is that initially the principal is the person who detains the child, not the police officer. Even though a criminal investigation is intended from the start when an SRO is going to be involved. However, what happens is the principal takes the lead in the criminal investigation, asks all the questions.
So what's your evidence that this principal was doing that in this case?
Their testimony, Your Honor. They testified that Mr. Baker.
Who is they?
Mr. Baker testified that he engaged Officer Carr's presence prior to even detaining OW, prior to knowing what violation, if any, OW committed against the school violation, against the student code of conduct. Just one moment, Your Honor. And once again, the female student testified that Officer Carr told her that not telling the truth in the investigation was a violation of school rules. That's the exact same warning Mr. Baker gave to OW in the separate room.
Well, was that factually inaccurate?
Well, it certainly is factually accurate. There is a violation of the student code of conduct for a student who does not tell the truth during a criminal investigation.
Right,
That's a
well,
part of
wait
the
a minute,
problem.
that's a different question. If a school administrator is investigating a violation of school rules, is it also a violation of their rules of conduct for the student to not be truthful?
Absolutely, Your Honor. And the problem is every single violation of criminal law is also a violation of the student code of conduct. And so that allows them to do this investigation together. The district court.
Wait a minute, go back. You're saying that whenever there's a violation of the student's code of conduct, that's a criminal offense?
No, the opposite way, Your Honor. Every violation of the criminal law is a violation of the student code of conduct. And so Mr. Baker testified, Officer Carr testified that when something is criminal, she gets involved immediately at the inception of the investigation. But she doesn't come down.
So if a student has a conviction for, assume they're tried as an adult, a conviction for driving under the influence, not on school grounds, it's a criminal offense. You're saying that that is converted into a violation of the student's school's code of conduct?
Well, it certainly is a violation of the student code of conduct, but that's not the types of investigations that are conducted on school grounds through the school principal. They limit those investigations to the criminal conduct that occurs on school grounds. So the district court distinguished Ferguson versus City of Charleston on the ground that it involved a search that was not based on reasonable suspicion, whereas OW had been searched on reasonable suspicion. However, the court does not distinguish special needs cases for that reason. This court said in the United States versus Curry on rehearing en banc in 2020 that the court applies the same primary purpose test to all special needs cases in all contexts.
So do you agree there was reasonable suspicion for the school principal to detain and question OW?
Yes, Your Honor.
Okay.
Absolutely. And we would prefer if educators could do all they within their power to ensure that schools are safe, that our students are going to be, I'm a mom. We want schools to be safe, and we want educators to be able to ensure the health, safety, and welfare of children. The problem is we can't have that if schools are also going to be operating or behaving as police
So what do you
department.
say that the principal should have done here that he did not do?
The problem is not, we feel like it could have been one way or the other, Your Honor. We could have had a school disciplinary investigation, or we could have had a criminal investigation, but we just can't have both, and they can't occur at the same time. The goal is that the officer arrives at some point later after the investigation, and he has to do some work
Well,
when
I
he gets on the
thought
scene.
that OW had already written two statements or confessions. He admitted to the principal that he had this photo before the school resource officer ever appeared.
Well, no, Your Honor, the very first thing Mr. Baker did was to engage Officer Carr. He went to her office, and that was her testimony, and that was also his testimony. That's the very first thing he did after he received the report from the teacher. Then he went to detain OW and took OW to a guidance counselor's office.
But when you say he engaged Officer Carr, wasn't the testimony that the principal said, hey, I have a situation here, but to get around TLO, wouldn't you need the officer directing the principal what to do? The officer saying, well, we need a criminal investigation, and here's what you need to do to get my evidence, or something that suggests that. Did that happen?
Well, Your Honor, TLO states that it would not apply if schools were working in conjunction with or on behalf of the police, and that's exactly what we have here. And so the memorandum of understanding between the police department and the
Let's
school.
go
But
back.
what's your evidence in this case? I know you have a memorandum where SROs are in schools and they try to divide up who's responsible for what. But what's the evidence here that the principal was working at the behest of Officer Carr when he asked OW to tell him what happened, or even asked, to see the phone?
Well, Your Honor, to start with the memorandum of understanding, the memorandum of understanding requires that school officials engage police officers at the beginning of every criminal investigation. But it does not require that the officer do any work. So what happens, and what happened in this case, is that after he detained OW, he took OW to an office where Officer Carr also was at, and that's where the investigation occurred. Between these
Well, I
two
thought
parties
the
at the same
evidence
time.
was to the contrary, that he had already been asked questions. He'd admitted he had this phone before Officer Carr ever appeared on the scene.
Well, Your Honor, the evidence was that OW was taken, Mr. Baker took OW to a small room inside, a printing room, inside of the guidance counselor's office. And he told him there, he admonished him and told him to be truthful during the investigation. That's when he took OW to an office where Officer Carr was at. And inside of the office is where all of the questions were asked. Those two statements, we don't know what happened in those initial two statements because Mr. Baker discarded those statements and told OW to write a better confession. And he gave that best confession to Officer Carr to be used in the criminal investigation. How do we know? And Officer Carr testified that she obtained that statement simply for the criminal investigation. She testified that she was not there in that room with Officer Carr, with Mr. Baker and OW to preserve order or
Okay,
discipline.
But to follow up Judge Rushing's question, what's your evidence in the record that when the school principal notified the school resource officer that he had this situation, which I assume is fairly normal, that there was some sort of concerted activity?
Well, all of the activity occurred in a concerted manner, Your Honor.
Right, but what's your evidence of that?
Mr.
I know
Baker-
you have that supposition and you make the allegation, but what we need is evidence.
Your Honor, Mr. Baker testified that, of course, he packaged OW's phone pursuant to Carr's directions. She advised him to place the phone in airplane mode, to power it down, and to give it to her to be used as a part of the criminal investigation. The fact of the concerted
Wasn't that after the confession and after the principal tried to find the picture and couldn't?
Well, yes, that was. However, just a moment. Once again, Your Honor, Mr. Baker and Officer Carr both testified that Officer Carr would not have been there at all had it not been a criminal investigation. Had it been, Mr. Baker testified that had it only been a food fight and something that did not involve a criminal act, that he would have never invited Officer Carr into the room at all. And so the fact that that's how the investigations normally work, but that the principal is the person leading the investigation and taking charge of the investigation on behalf of the police officer is what's concerning.
But
In addition,
counsel, can I ask a question on that? It sounds like what you're saying is that if you have conduct that would violate school policy and might also create criminal liability, that the principal can do an investigation, but you got to keep the resource officer away. And then the resource officer can come in after that's done and do their own work. And I wonder if that's really what I forget, I'm getting tongue-tied on the letters, TCL, I forget the name of the case right now. But it seems to me the question from that case is there needs to be more direct, that the officer is directing the investigation. And so I wonder if the cases require the separation that you're suggesting, or rather just prohibit the officer from directly controlling and telling the principal what to do.
well, Your Honor, it's the fact that this is how the investigation works, so they already know what's going to happen prior to coming into the room. However, there's also proof on the record or from their testimony that Officer Carr would chime in from time to ask questions while Mr. Baker was leading the questions to OW. So there was communication going on at the same time.
I want to be sure I understood what you said. I took it, what you said was that the principal and the police officer had agreed in advance on what they were going to do.
Your Honor, we do not have any communications between those two ahead of time other than.
Okay, well, I might have misunderstood what you said.
Other than Mr. Baker engaging her presence at the beginning of the criminal investigation. However, we know while Mr. Baker was asking OW questions, Mr. Baker testified that Officer Carr chimed in from time to time and asked more questions. And we can only assume that those questions were incriminating as well and potentially leading his questioning as well. Your Honor, once again, the court, and I'm sorry, Your Honors, I see that I'm out of time.
If you got something you want to tell us briefly as part of your opening, go ahead, but you'll have some rebuttal time.
Your Honor, we also argue that even under TLO, if this case were to be argued under TLO, meaning that they were to obtain special needs exception, which they're not entitled to special needs exception, where law enforcement is the primary purpose of the search. This court said that in United States versus Curry in 2020 when it heard it en banc. My second point that I wanted to communicate is that even under TLO, Mr. Baker needed and he did not have probable cause for the search. Third, following a warrantless search is the government's burden to establish a valid search exception and the scope of the search, and relying only on the exigent circumstances exception and failing to establish the scope of the search, the appellees have failed to meet their burden. And finally, we want to note that OW...
I don't know if the scope of the search was limited to looking for this photo.
Well, we don't know where he searched inside of OW's phone. He could have went so far back, and he could have went further back than necessary to view this image. He could have also searched other places in OW's phone.
Is there any evidence in the record that he did anything other than go just to the photo section of his phone?
No, Your Honor, but it's their burden to establish what the scope of the search was. Although we do admit that he searched the photo gallery, we don't know where else in the phone he searched, and it's their burden to establish that, Your Honor.
All right, thank you very much. You've got some rebuttal time. Ms. Lauren?
Thank you, Your Honors. Ann Laren with Pender and Coward on behalf of the school board and Assistant Principal Reed Baker. May it please the court. As OW's counsel conceded, violations of the law on school grounds are also violations of the Code of Student Conduct. In this case, OW took a privately sent explicit photo of a fellow classmate and shared it and showed it at school during the school day. OW is not the victim here. AF is the victim. Children have killed themselves over similar situations of what OW did to her. This is a very serious offense that required the immediate action and investigation by the assistant principal. As the court is clearly familiar with the facts of this case, a brief rendition, I believe, is still helpful to hammer in the timeline. OW and AF were both 7th grade students at Kempsville Middle School. They were texting each other over the winter break when each of them were at their respective homes. Months later, in March of 2019, while at school, OW was showing the explicit photo to other students. AF became upset. Another student complained to a teacher who reported the incident to Reed Baker, and then Baker investigates. The allegation was potential possession of child pornography, which is, of course, a criminal offense, and that criminal offense is also a violation of the Code of Student Conduct. TLO establishes that on school grounds, the standard is reasonable suspicion. Certainly with an allegation that a student is showing a photo on his phone at school grounds.
So if there's reasonable suspicion, assume there is reasonable suspicion, I think maybe your colleague conceded as much. So it seems to me the question or the issue she's pushing on is, while the principal may be the primary one asking the questions, here we have a situation where there's at least a question of fact as to whether that was being directed by Officer Carr. And the evidence she says that would support that is, one, that there's this memorandum of understanding. Two, that at the very outset of this, she contacts Officer Carr. And I think there's also references that you bypassed other security officers in doing that. And three, that Carr is there during the questioning and participating in the questioning. And so I think the issue is, conceding reasonable suspicion, maybe she doesn't concede it, but if reasonable suspicion, even if it's conceded, you still have an officer who is, coordinating the principal's investigation. Why isn't there a question of fact on that? Or am I missing the law wrong? Tell me on that issue, what's your response to that?
We would say it's not a material question of fact, as stated, as in the previous case law. In New Jersey versus TLO, there was an officer there. In Wofford v. Evans from 2004, this court extended the TLO analysis to cover law enforcement officers when investigating at school when the student is also suspected of breaking the law. So this court has already said that the officer, when investigating a violation of school conduct that also breaks the law, that they have the benefit of the reasonable suspicion standard. So at that point, we would argue that it is not a material dispute of fact.
Walford makes that immaterial effectively. Correct. Is that correct?
That's correct. Also, counsel has conceded that, although different from what she pleaded in the briefs, that the memorandum of understanding itself was not the sole basis for a conspiracy. And that would make sense given that these memorandums of understanding are extremely common. Not only is there a model memorandum of understanding from the Virginia Department of Education, other states have similar ones, and so does the U.S. Department of Justice. So proposes these memorandums of understanding when dealing with the interaction between school resource officers and the schools. The core holdings of the cases where the dividing line seems to be is whether the investigation involves criminal conduct occurring on school grounds versus conduct outside of school grounds. And the line of the differentiation would be that a school resource officer cannot be used to investigate a criminal act outside of school, but question the student in school by using the administrator to bypass constitutional safeguards.
Where do you, is that right? I can appreciate if you got an action taking place outside the school, that would make it a stronger case that you're using the school to investigate, really for a criminal action.
Well,
But-
in
but-
that-
well, But, you know, there's, you know, lots of law about how you don't, you know, how you don't forfeit your, you know, constitutional rights at the schoolhouse door, you know. I mean, so I really, I wonder whether that's the line that the law really says we look at.
Well, for the point of fact, that would go to the jurisdiction of the school official. If a criminal act occurred outside of school grounds, the school official would not have the jurisdiction to investigate, except in a very limited circumstance, that
What about
violation.
Fifth Amendment? I mean, your TLO talks about Fourth Amendment.
Yes.
There's a claim that the parties don't deal a lot with, which is the Fifth Amendment coercion claim. I mean, and I didn't see authority that really helps us in a TLO sort of way strike that balance between you still have constitutional rights, but they're not the same as in school as there might be elsewhere. I didn't see anything that really tells me how to make sense of that with a Fifth Amendment coerced confession claim. Do you
Well-
have a suggestion about how we look at that?
Yes, I would suggest that's the U.S. Supreme Court case of JDB versus North Carolina. And in
Okay.
fact, in that case, the incident that was being investigated was a criminal act outside of school. In that case, it addressed the voluntariness of confessions of minors. That case also involved a 13-year-old, and says that you consider the totality of the circumstances in whether or not the student
So
would
you
feel
can
they were free to
consider
leave.
age and
You
whether.
consider age,
yeah.
the length of the questioning, the circumstances of the questioning.
You
In this,
consider whether Miranda rights were given?
they found in that case it was not necessary because the student was not in custody and therefore the Miranda rights were not triggered.
But
And-
isn't that a factor in whether a confession is voluntary or not?
Oh, I think in that case, and again, the JDB versus North Carolina case found that the confessions were voluntary. But those also involved an investigation by the police behind closed doors. Whereas in our case, the investigation was by the school official in the guidance office with the door open.
Let me
for-
step back, and I appreciate that. I'm sorry to cut you off, but I want to make sure I understand the approach, the test in school for a Fifth Amendment coerced confession case. And tell me what you think that test is based on the case you're just describing.
Certainly. Well, I think in the case that I was describing, if you mean the North Carolina case
Yes.
from the Supreme Court, that in that case, it would be whether the student felt they were free to leave. They're not in handcuffs. They haven't been told they're under arrest. There is the questioning. But the issue is the totality of the circumstances. And again, I would point to that case because that was questioning done by a police officer behind closed doors. In
So
this case,
are you saying that the standard, the test is the same as it is for any involuntary confession case, but we just take into account the circumstances, and in school cases, the circumstances may be, you know, unique in that you're on school grounds, you're talking to a faculty member, and those sorts of things. But I don't hear you articulating a different test. Is that right?
No, I believe there is a different test. As Judge Quattlebaum asked me to talk about the JDB versus North Carolina case, with regard to our present case, if there are Miranda warnings, that is not something that would be implicated when the administrator is doing the investigation of a violation of school policy on school grounds.
So is that, I just want to be sure I understand your argument. Are you saying the test is simply different where the school administrator is doing the interrogation?
I believe if the school administrator is doing their own independent investigation. In this case, while OW argues that the police officer was directing the investigation,
Right, I understand
there are
that.
no.
What I'm more interested in is what do you say the standard is in that circuit, when it's the school administrator doing the interrogation?
Well, when the school administrator is doing the interrogation, the school administrator is investigating a violation of the code of conduct. And this is where TLO, and Wofford v. Evans talks about your different, the school is just a different setting, and that you have the school administrators, when investigating a violation of student conduct, they have the right to investigate. Furthermore, in this particular case, I would direct that there is a bring your own device policy with the school that both OW and his parents signed off on that states that the school administrators have the right to search a phone if they have a reasonable suspicion that a violation of the Code of Student Conduct has occurred. That is, and that students and parents, devices come to school at their own risk. And so this was, in essence, almost a waiver of sorts that by OW using this phone on school grounds and violating the Code of Student Conduct, he has already acknowledged that the administrator has the right upon reasonable suspicion, which appears to clearly be here in this case, to search that phone. And OW in this case
So to
already
be clear,
confessed.
the district court didn't use a waiver basis.
Correct, and that it was not the waiver, it does not have to be the waiver basis, but in this case, with that bring your own device policy, it's certainly cited by the district court as putting the students on notice of the standard. The student chooses to have a phone at school
So
and
that's
use it.
part of the totality of the circumstances? you
Yes,
say?
and also in this case, OW was not in custody. He was being questioned in an office, in a familiar setting with a school administrator with the door open. And so under the other case
Is
law.
that custody question a question of fact? I mean, typically a question of fact?
I believe in this case, in light of the precedent, it would be a question of law.
So, I mean, I hear you, he's not in a jail. That said, going to the principal's office from my days was not a signal that things were going well for you. So he probably felt like he was in some trouble there. He had an officer there who has who's uniformed and has a gun. He's a minor. Are you saying he really felt like the circumstances were such that he could have just gotten up and walked out of there? A reasonable, seventh grader would have thought that?
He probably would not have thought that, but we would state that that is not material in this instance because the school law is simply different because the school administrators need to be able to handle matters occurring on school grounds. That's why TLO sets forth the different standards, why Wofford v. Evans extended even the latitude that an administrator has to a police officer in this setting. And so to impose a requirement for any time a student went to the principal's office to say you must have Miranda warnings would make it impossible to efficiently run the school.
All right, we've given you a little extra time, and
Thank you.
I see you're sharing it with co-counsel. So, Mr. Kurt, we'll hear from you.
May it please the court, my name is Joseph Kurt, and I represent Officer Marie Carr in the city of Virginia Beach. Appellant's claims against Officer Carr in the city are without merit. The first thing I would point out is that count 1 of the second amended complaint does not assert a Fourth or Fifth Amendment claim against Officer Carr. So contrary to what Appellant's attorney said on remand, that would not be at issue.
What about,
Instead,
does the conspiracy count apply to Officer Carr?
That's right. So this case against Officer Carr is about the conspiracy count, and that claim is unsupportable with regard to both the facts and the law. I'll start with the law. A conspiracy claim requires, in addition to coordinated action based upon an agreement, a resulting constitutional violation. And we agree for many reasons, including what counsel for school appellees said, that Mr. Baker's actions were clearly lawful pursuant to TLO and its progeny.
Does
And-
TLO tell us about Fifth Amendment coerced confession?
No, it doesn't. And I will make I'd like to address, in a moment if you would, the record very much that speaks to that.
You don't have to do it now, do it everywhere it suits you, but if you would not only address the record and why you think there's not a Fifth Amendment issue, if you'd start with the test and how we consider Fifth Amendment claims in a school setting.
Well, let me take that point now then. I think that the test going to JDB is still, it's a totality of the circumstances test. It includes the fact, of course, that administrators do not have to give Miranda. And the court says it includes age. But here, there simply is no evidence of coercion. and there certainly is no evidence of coercion involving Officer Carr. And this is a striking part of the record that I'd like to point out that we really didn't on brief. And it's the fact that...
I think the plaintiff, though, argues that the setting was inherently coercive. You have a young child, they've been taken out of class, they're in a small room. I don't know that you can realistically expect a 13-year-old to think he can walk out. But she says those, as I understand it, that those are sufficient facts to show a coercive atmosphere.
Well, they wouldn't be according to the cases that we've cited, and they've cited none to the contrary, but we cite JD versus Commonwealth, which is a Virginia state court case, that says there's not even a custodial investigation where they didn't even get to the coercion part, but it's not a custodial investigation just because a police officer is there. One other thing that I'll point out, I think this really applies more to school defendants, but in State versus JTD that we cite on the record, this is a Florida case, the question of whether the student is free to go is really not completely apt to these cases, because what it says is that in schools, as a student, you're not free to go where you are. I can tell you that I'm a proud former high school teacher of 12 years. Students cannot go where they want. So
And
that
related-
question cannot be strictly...
And that makes some sense, and it feels, that's what and likewise, I suspect school administrators coerce confessions of stuff all the time. Coerce sounds real bad in this setting, and maybe it has criminal implications, but maybe you're kind of suggesting that's not the case. But I wonder if that's even, if that's, I would think a lot of schools would say, in some way, we do coerce confessions to at least problems with school rules and violations.
Well, that may be the case in many circumstances, and I think it goes to the spirit of so many of these cases related to TLO and other circumstances where courts understand schools are complex and challenging environments, and students are very vulnerable in terms of violence. But a student like AF, think about the vulnerability of that girl. While that photos, that's the worst day of her life. Those are the worst moments of her life. And school administrators who are not trained in the law, courts make this point over and over, they've got to have flexibility to take care of their school and make sure that there's order there.
Is there any argument, though, that the standard for voluntariness is different? I know we're using the words coerce, and maybe we're doing it in kind of a colloquial way that, when my teacher is upset with me, that it coerces the truth out of me, right? But this test for the Fifth Amendment or the 14th Amendment is that the defendant's will has been overborne such that their statements are involuntary.
Yeah.
So I don't want us to lose sight of that standard. Are you saying that standard is different in school and it is somehow a different standard, or what's your point on that?
No, Judge Rushing, you are correct. That substantial standard of the question is whether OW's will was overborne. That is the question, whether you're in schools or whether you're outside of schools. The problem for them is that the record, really again going more to Mr. Baker, is about the pressure. It starts with the complaint. It says, he told OW, tell the truth. He used his trusted relationship with him to say, tell the truth. That is not evidence that he overbore OW's will. And with regard to my client's participation, I think it speaks generally to what happened. The facts are really clear, and it's really striking that OW, for years, was telling the same story multiple times that Officer Carr told in her original report from the date of the incident. And I'll point you to Joint Appendix page 1331. This is OW's own motion to suppress from his criminal case. And on that page, he is very express. Baker received the reports. Baker started this investigation. He starts calling students down, not Carr. It was Baker that retrieved OW from class that day. He took him into the guidance office and he started asking questions. According to OW, Carr wasn't there at the beginning. That story changes later. But OW says Carr wasn't there. She came in later and started taking notes. Again, OW makes clear, while Carr's taking notes, Baker is still asking questions. And it is to Baker's questions that he says he, quote, made a full confession to Baker's questions. And that is also consistent with the JDR court's finding that Carr, quote, did not participate in the interview at all. That's on Joint Appendix page 1350. Appellant's own complaint, especially at Joint Appendix pages 29 and 30, tells essentially the same story years later. This is Baker's investigation. He gets a report. He does what anyone would want a school official to do: call students out of class and try to get to the bottom of it. The only little change there, he omits whether Carr comes into the office later or not, but he also says Carr sat silently taking notes. So it is true, OW later tells a different story during deposition, but he does so in a manner that further undermines his claim because he's vociferous. I told Baker the truth from the beginning, he says. And he says he made a full confession before, in writing and orally, before Officer Carr was involved or even present. And so, recognizing that this is fatal to their claim, Appellant on brief at page 5 in the opening brief, and says it again in the reply brief, says, OW was 13-year-old. You cannot trust that deposition testimony. And I do take that point. And what Appellant says to you is instead you should trust Carr's report that's contemporaneous, from March of 2019. Well, the problem there is that Carr's report says the same thing that OW was saying all along. This was Baker's investigation. Baker's doing all the questioning. Carr makes it expressly clear she did not ask a single question, and that is the truth. There is no disputed material fact about those
So
things.
if Carr had taken OW down to the police station and asked the same questions that Baker asked and said, no, that statement's not good enough, didn't give Miranda rights, would you have a Fifth Amendment issue?
You potentially would. It would be a very different set of circumstances. And, you know, I
doesn't that
believe there are
tell-
courts who point to, if it's the SRR who's driving the train and asking questions, they've got to give Miranda rights. We don't dispute that, and that's a good policy.
Right.
And so with that, if there are no further questions, again, I would insist that there is really no genuine disputed material fact on these issues. The case law and the record are clear on every key point. The district court properly granted summary judgment, and we ask you to affirm.
All right, thank you very much. Ms. Gaines, you've got some rebuttal time.
I can't start this without discussing suicide. Your Honors, not only did Mr. Baker pass by 4 security guards, but he also went to the guidance counselor's office. There were no guidance counselors there. This was the perfect time for guidance counselors who under Virginia Code 22.1-298.1 D7 are required to be trained on students' depression, trauma, and suicide prevention. Where were they? Also, we have to speak to TLO once again, Your Honor. TLO is a special needs case. The appellees want to distinguish TLO and make it appear that it's only a school search case. It's a special needs case. The same special needs doctrine that the court applied in Ortega versus O'Connor, when it turns to government workplace searches. The exact same special needs doctrine that was applied in Ferguson, the same special needs doctrine that was applied in Griffin and its progeny, Knights and Sampson. And even in those cases, the court found where there was an investigatory purpose, despite the fact that probationers were already criminals, convicted criminals, but where there was an investigatory purpose in Knights, the court still found the special needs doctrine did not apply. And instead it took us to
Can I ask you about, I know we've been debating the parameters of TLO and when it does and doesn't apply, but if we thought the confession was voluntary, would the principal then have had probable cause to search the phone. He would have other students saying the phone has this picture on it, and he would have OW saying, my phone has this picture on it. Would that be probable cause to search the phone for the picture?
No, Your Honor. Later on, for Carr's second search, she testified.
No, we're not talking about Carr. You only sued the principal
Yes.
over the search.
Well-
So did the principal have probable cause when other students say the phone has this picture and OW confesses, I sent the picture, it's on my phone still? Did the principal then have probable cause to search the phone for the picture?
No, Your Honor. And the reason for that is because Carr's search came after Mr. Baker's search, and she still did not have probable
Why
cause.
are we talking about Carr? You did not sue Carr for a violation of the Fourth Amendment. I'm asking about the principal.
Yes,
Did
Your
the
Honor.
principal have probable cause?
So the problem is that they understood that 12 and 13-year-old children lack sufficient indicia of credibility. Carr testified.
I'm asking a hypothetical. Assume that I think the confession is voluntary, and that the other students, which is not disputed, other students said the phone has the picture. So other students say it, and now we have a voluntary confession that it's on the phone. Can the principal then look at the phone?
He only spoke to OW prior to searching OW's phones. There was no indication that he had already spoken to those other children and corroborated what OW had said. He only spoke to OW. And once again, Officer Carr testified that she knew that children of that age lacked indicia of credibility, and that she
Okay,
could
So
not.
are you answering my question, yes or no, that there was probable cause to search the phone?
No, Your Honor.
There was
There
not.
was not probable cause to search.
And
the
why
phone.
is that?
Because the children lacked indicia of credibility under Doyle. There was one element of the, well, first of all,
Now, was
Mr.
that
Baker
an
testified.
argument made in the district court?
Yes. Yes, Your Honor. And Mr. Baker testified that he didn't know the elements of child pornography.
So you're
Under
saying there's
Doyle.
never, you can never trust a child who says, this picture is on the phone, therefore you can never have probable cause because you can't trust a child's testimony?
Well, no, Your Honor, but she testified that she knew children would exaggerate in these kinds of situations. She knew that she could not rely on.
Sorry, Officer
just their
Baker
statements.
said that?
No, I'm sorry, Officer Carr testified. Her search.
Okay, but we're asking whether Baker could look at the phone.
Your Honor, we believe that Mr. Baker did not have probable cause to search the phone.
All right. You got anything else you want to add this morning?
Yes, Your Honor, I just want to touch on the fact that, once again, Wofford versus Evans is an exigent circumstances case. It is not a special needs doctrine case in the way of Ortega, Ferguson, Griffin, Knights, Sampson, which TLO is certainly one of those cases. Wofford is in the, is an exigent circumstances like Curry. And in United States versus Curry, this court said that the special needs doctrine does not include exigent circumstances, and there are two separate doctrines. And the appellees are not relying on the special circumstances or the special needs doctrine. Your Honor, apparently the police department concedes that there was some coordinated conduct sufficient to establish an agreement between the two separate entities. Also, voluntariness is a question of fact. It should have also always been enough to get us to a jury. I also want to speak on Officer Carr's report, which, as Mr. Kurt stated, certainly did have, she authored that report contemporaneously with the investigation. And what it says in that report was that OW was not telling the truth. She was sitting in the room with OW and Mr. Baker, and OW was not telling the truth. She testified that Mr. Baker told OW what he was saying did not make sense. And eventually OW told the truth during that investigation, but, and that's all, Your Honor. If, once again, we'll ask the court to reverse or vacate the judgment of the district court.
All right, thank you very much. We'll come down and greet counsel and move to our next case. We're going to wait for the courtroom to clear. All right, our next case is Lucas versus VHC Health. And let's see, Mr. Wolfman. And Ms. Samuels is also going to argue, right, but Mr. Wolfman, you're doing the rebuttal.
Yes, Your Honor.
All right, we'll be glad to hear from you.
May it please the court. This court should reinstate all of Ms. Lucas's claims. I'll begin with race discrimination, then turn to retaliation, and finally address disability discrimination. As to race discrimination, Ms. Lucas alleged that her treating physician informed her that she does not take care of black people, and then terminated her care shortly thereafter. That is an allegation of classic, direct evidence race discrimination, and it's more than enough to withstand a motion to dismiss. In holding...
Counsel, do you think on that point alone, do you think you need the amended complaint to do that?
We do not believe so, Your Honor. But
Because the amended complaint clarifies the timing of that statement with respect to the termination of the doctor-patient relationship. Is that, it seemed to me at least.
It does. And so if I could extend my answer, which is that we don't think we need the amended complaint on that claim or any claims, as we say in our brief. But certainly the amended complaint, if you were concerned, would not have been futile. It adds a date. It adds additional allegations of race discrimination. For instance, like telling Ms. Lucas to go to a hospital that serves predominantly black community in the District of Columbia.
The district court, I guess, determined futility because of the reasoning that one incident is not enough, and maybe if that's the test, it would not change a lot regardless of when it happened. You dispute that?
I do dispute that, and let me explain why. The doctrine is the stray comment doctrine, not the one incident doctrine. And so it's no different here than if an employer had a policy of not hiring Catholic workers, learns that an employee is Catholic, and fires the employee a week or two later. That's this case. So that's not a stray comment. The stray comment doctrine is when a comment is separated in time or context or the authority of the decision maker. None of that is present here. If the court doesn't have anything further on that, I will turn to retaliation. As to retaliation,
So
I
what
want to
about
begin...
disability, though? You have a separate claim from disability.
That
right?
is correct, and I can turn there if the court wishes me to.
Well, you have a race claim, a disability claim, and then you have retaliation. So I thought disability was at least somewhat tied up with your retaliation claim.
That's right. Can I turn to the retaliation and I'll go to disability if that's okay, Your
All
Honor?
right?
No one here disputes the basic elements of retaliation, that she complained of discrimination in the provision of health services, and then VHC took a materially adverse action against her. The question is whether the ACA bans retaliation in the first place. It does. The ACA broadly prohibits discrimination and incorporates Title VI, Title IX, and the Rehab Act, which also ban discrimination. The courts have universally held, most prominently the Supreme Court in Jackson and this court in the Title VI decision in Peters, that an express ban on discrimination, standing alone, that word, standing alone, includes a ban on retaliation.
But the Supreme Court has said we look at it differently if the statutory scheme has an express retaliation provision.
That's right. And with respect, this statute does not. If you're referring to Section 1558, 1558 is a whistleblower protection for employees of entities that provide health services and perhaps insurers. And it wants to encourage whistleblowers to come forward internally with respect to violations of the Affordable Care Act. It's not an anti-discrimination provision. So for instance, if an employer or an insurer is violating,
Well, it has to be an anti-discrimination provision in a broader sense, because retaliation is a form of discrimination.
that is correct, but not in the
And
sense.
subsection A says, no employer shall discharge or in any way discriminate.
Right, that's right. And so it is discriminatory in that sense. But what I meant, Judge Agee, and I didn't mean to be evasive at all, is that 1557 is trained on particular types of historical discrimination by incorporating Title VI, Title IX, and the Rehab Act. This is a whistleblower protection statute that goes much broader in one sense, because if you violate, if there's a report of any violation of the Affordable Care Act, such as the minimum care provisions, such as the prohibition on, with respect to the giving of credits to certain individuals. If a person notes, an employee sees that the healthcare agency is violating these provisions, they want to encourage people to whistleblow because they're internal to the organization.
Sure. I mean, let me just stop you. I think I don't disagree at all that 1558 encompasses someone blowing the whistle on conduct that doesn't involve them. So if the question is, does it include that? I don't think there's a whole lot of question that it does. The question I have, though, is doesn't it also, by its express terms, include retaliation against someone who complains, much the same way that the Title VII retaliation provision does?
It's stated at that broad level of generality, yes, but it's about something entirely different. This is.
How can it be about something different if it includes the retaliation? I mean, if saying, a provision includes retaliation about your own reports of violating the statute, and it includes discrimination if you report someone else's violations of the statute, how can you say it's about something else? It's about something more, but not something else.
Well, it is about something more, but something quite less than 1557 is aimed at, which is 1557 is principally aimed at first parties, if you will, people who are discriminated.
1557?
57, yes.
Correct.
And 1558 is trained on third parties to a transaction.
Where does it say that?
It doesn't say that, but that's the purpose of it, because it applies to
So
any.
if you think someone brought if Lucas here had sued for retaliation under 1558, that we should dismiss that as, not supported by law?
She could not sue under 1558 because she was not an employee.
Okay, let's say there's an employee who's retaliated against, and not reporting a third party's, some retaliation. Hey, not saying VHS is retaliating against all these people. They retaliated against me. I'm an employee of VHS, and I'm bringing my case under 1558. That would clearly be okay, right?
I take the point that there is maybe some narrow.
Yes?
Yes, I take the point that there may be some narrow overlap. But these, in general, these are aimed at quite different things. 1557 is to protect what I'm calling first parties.
Why do you
1558
say
is to
that?
protect third parties. Because we know historically that Title VI, Title IX, and the Rehab Act are to prevent discrimination against individuals who suffer the discrimination. We know that whistleblower statutes like 1558 are to encourage people who are internal but third party to the transaction to blow the whistle. That's the purpose of whistleblower statutes.
But you want to talk about purpose. I mean, don't we get the purpose from the text?
Yeah, I'm looking at the text, and let me say.
But you just told me, I thought, and I don't mean to put words in your mouth, I thought you just told me that the text of 1558 would permit an employee to bring a retaliation case.
It would. That 1558 would permit that. Let me say one other thing, or a couple other things if I might. 1557 and 1558 may appear somewhat related in the sense that they are next to each other in a section of miscellaneous provisions of the Affordable Care Act.
So but they were enacted at the same time?
They were, but so is the whole act. The 1558 is codified in an entirely different part of the U.S. Code.
Part of the relevant point, that they were enacted at the same time, because you have a statute here, 1557, that clearly goes to discrimination in any health program or activity. But it has all these additional code sections before that, which would seem to say if you have a health discrimination claim, it has to fit within one of these four statutes.
That is correct. This court said that in Basta. I agree with that. Let me make one more point about 1558's irrelevancy. I don't disagree with that point at all, Judge Agee. I think that helps us because those statutes have historically, time after time after time after time, been said to include a prohibition on retaliation.
Correct.
But let me say one other thing about this. When I first saw 1558, I was tempted to say, when Congress knows how to deal with employees, it'll say so expressly. It didn't say it in 1557, therefore we win. But I think the better answer is they have nothing to do with each other. So I want to end with this, which is that 1557 incorporates Title VI, Title IX, which is about education, the Rehab Act, which is about discrimination often in health services. It incorporates statutes that do not train on employment, right? Like Title VII does. These statutes do not train on employment, and it would be spectacularly odd, therefore, to import a limitation about employment in a whistleblower protection statute, because whistleblowing is historically about employment. Okay.
So your rehabilitation, your retaliation claim is based on which of the particular statutes that are included in 1557?
Of Title VI and the Rehab Act. Again, they correspond to the race discrimination claim and the disability discrimination claim.
All right, and tell us exactly what is the disability claim? You
Okay.
never got to that.
Okay, I see I'm eating into my rebuttal, but
That's all right.
I want to do this briefly if I could. Ms. Lucas alleged that because of her diagnosis of PTSD and other things, and other disabilities, the defendants, I'm quoting now from the complaint, asserted that her physical pain was not real, it was only in her head, and despite contrary medical tests, that's at JA 8, a hospital staff made it clear to her that they believed because of her diagnosed emotional conditions, again I'm quoting the complaint, she was fabricating the seriousness of her contractions and pain. This is at JA 18-19. Again, shortly thereafter, she's dismissed from the medical practice. And so we believe at the...
Right, but so here you have healthcare providers who make a medical diagnosis, if you will, that this is psychosomatic. The way I understand your argument is, despite that medical diagnosis, in order to avoid a disability claim, they have to act contrary to their medical judgment to provide the plaintiff a treatment that they do not think is medically authorized.
That is not our position.
All right, so you
and
tell us what it is.
I would like to explain why. We acknowledge that a claim about disability discrimination in the healthcare setting is a difficult one. Because yes, of course, healthcare providers have to take into account people's ailments, including things that are disabilities as a matter of law. But here, the allegation is that they thought, and they indicated to her that the pain was, as you say, psychosomatic, contrary to medical tests indicating that she was in pain. So there are going to be circumstances in which a person can make out a claim of disability discrimination if you can prove that the healthcare provider intended to dismiss this person because of their disability. Is it going to be more
Right,
difficult?
but I don't think you make I don't think that allegation is there. In fact, it pleads to the contrary, that this is what the healthcare providers believed, that this was a psychosomatic condition. I mean, that's her own pleading.
I don't believe so, Your Honor. She elsewhere in the complaint, she says, you know, it was obvious she was writhing in pain. Her stomach was visually balled up. She was crying out in pain. And contrary to medical tests and medical records indicating that she needed pain medication. So she thought they told her that she was fabricating her pain, but they really wanted to dismiss her because of her disabilities. Now, let me say this.
All right, do it quickly, because we've let you go way over.
Yes, let me just, but I do want to wrap up here. We are at the motion to dismiss phase. I realize that this case requires more facts to get us over to the next stage, summary judgment and trial. And we plan to do that. But she's entitled to all inferences in her favor.
Are you, okay,
No,
that's
no,
one
no,
quick
go ahead,
thing.
go ahead.
If we agree with you on the motion to amend, doesn't your amended complaint not include those allegations about disability?
No, I mean, I think that the allegations I read you are from the initial complaint. What the amended complaint adds, and the amended complaint adds that a lack of trust is a symptom of
Yeah,
PTSD.
but it removes the stuff that they thought it was in her head.
That is not my understanding, Your Honor.
I'll double check.
Yes, that is not my understanding.
Okay.
But I do want to just emphasize that we are at a motion to dismiss phase. She's
Sure.
entitled to all inferences in her favor. Thank you.
All right,
Your Honor.
thank you, Mr. Wolfman. We'll give you some rebuttal time, Ms. Samuels.
Good morning, Your Honors. May it please the Court. Jessica Samuels on behalf of the United States. I'm here this morning to focus on
I'm sorry, you're representing who?
the United States, the federal
Okay,
government.
all right.
And I'm here on just the narrow, discrete legal question about whether Section 1557 of the Affordable Care Act encompasses retaliation. If I could, I'd like to jump kind of straight into the discussion that Judge Quattlebaum, you were having with counsel for plaintiff, which is whether Section 1558 is an express anti-retaliation provision. I think the easiest way to think about this is that the courts have interpreted what Congress has done by looking at whether the anti-discrimination regime is, some of the words courts have used, broad, capacious language, undifferentiated, just one sentence, thou shalt not discriminate, as compared to an anti-discrimination regime that is precise, is a word the courts have used, complex,
But they're talking
exhaustive.
about in their, as I read it, particularly in Nassar, they're talking about the overall statutory scheme. It doesn't look to me like they're looking at the specific anti-discrimination provision. Maybe you disagree with that, but as I read Nassar, there's reference after reference to statutory schemes, statutory structure, and there's certainly some anti-discrimination cases that are very short and broadly prohibit. The ACA, I don't think it, maybe you would argue 1557 is short and broad, but the ACA as a whole is probably not going to be characterized as short and, short, sort of simple, broad
Agreed,
thing.
agreed, Your Honor.
So the question is whether you look at 1557 alone or whether you look at the act as a whole. Do you agree with that?
I do agree that's the question, but I think the reason that we're on the broad, undifferentiated side of the line is because 1557 is the anti-discrimination
Right.
regime, but the statutes the court was looking at in Nassar were Title VII, which is an anti-discrimination regime, right? Title VII wasn't buried in something, a law that addressed an entire industry, that, reformed all of healthcare, all of health insurance. So the issue is
Right.
that the Patient Protection and Affordable Care Act, to say that by including other things, it undermined the anti-discrimination regime, it's not apples to apples in that way.
So it seems to me, it seems to me if rather, as I read 1558, I get why you would label it, and you did in the footnote in your brief, a whistleblower claim. And your colleague says that, and like I mentioned earlier ago, I think it would certainly encompass whistleblowing. But, I think as your colleague conceded, and I think he had to, that it would encompass an employee's direct retaliation claim too. And so I'd love to hear if you disagree with that. I'd be open to hearing that. I think the better, and I think, Nassar then presents a real question of how we look at this. I think that the contrary argument would be, well, if you were just saying discrimination on the base of race, age, gender, maybe Nassar is right on target and this 1558 is a problem. I think the best argument is that 1557 incorporates specific statutes that have been interpreted to include retaliation. So are we able then are we really in Nassar land there or not? Does that make sense in terms of, kind of how to figure this out?
I think that Your Honor is looking exactly to the same authorities that we think control this, but we think they go the other way.
Oh, I'm not surprised. I'm not saying where I think they go. I just want you to help me out.
Here's why. Let me start with the kind of 1558 coverage question, and then let's turn to what Nassar says about it. The 1558 coverage
So we're
question.
going to give you an extra minute or two, but your time is running.
Thank you, Your Honor. 1558, I agree, covers employers. And it covers employers who blow the whistle on conduct that violates the ACA. As Your Honor noted, that is a long list of things. You can violate the ACA many, many different ways. For example, denying coverage for pre-existing conditions. One of the ways that you can violate the ACA is by discriminating on protected characteristics in violation of 1557. So I agree that there is a narrow overlap between these statutes. Again, a hypothetical overlap not presented by this case, I think, is an important point to note. We don't have an employee here. This is a Heartland 1557 patient healthcare case. But for the sake of the interpretive exercise, that overlap doesn't mean we read 1557 any narrowly, because the rule of construction isn't that a cause of action can only arise under one statute or the other. Courts have consistently, especially in the anti-discrimination context, in the CBOCS case, the Supreme Court noted that Congress has acted with a general intent in the anti-discrimination context to provide overlapping protections against discrimination, which we read to encompass retaliation. So I understand Your Honor's point that there could be some hypothetical overlap about maybe an employee who is retaliated against for complaining about discrimination very well may have a claim under both of those statutes. I don't think that's a problem. I think that Congress was rooting out two different kinds of ills, and the fact that they may have caught.
That would be a lot of what Justice Ginsburg says in Nassar, and that turned out not to be the law after Nassar. So Nassar, as I read it, says when Congress imposes a specific retaliation claim, and it calls that its most pertinent for present purpose, its most important issue in saying that general anti-discrimination claim in Title VII didn't cover retaliation, was that they had a retaliation claim, they were thinking about retaliation, and they defined the contours of retaliation. And here, one could say, perhaps, that very same thing happened.
I don't think so, Your Honor, because in Nassar, the court was distinguishing between anti-discrimination regimes that contemplated retaliation. So Title VII had an express retaliation provision. Here, Section 1557 is the anti-discrimination regime. It just happens to be enacted in part of the Patient Protection and Affordable Care Act. So if Congress had enacted Section 1557 as an anti-discrimination regime the next day or something, it's just a technicality, I guess, that that regime is in the next to 1558, that's how they took them up. And
But I mean, Congress passed an act.
yes, Your Honor, but
And they got the act, and right next to each other are two provisions. I mean.
But you can see those provisions they enact, I'm sorry, Your Honor, may I continue? The provisions amended different sections of the United States Code. So 218C,
I
section.
understand that, it's
is-
the FLSA.
Exactly, and so we see here that Congress, I agree in the same act, but they're enacting in 1557 an anti-discrimination regime on protected characteristics. And in 1558, a whistleblower regime based on violations to the healthcare law.
What's your authority
Can I
that
ask-
we should look about, I'm sorry, Judge Rushing, go ahead.
No, I don't want to cut off Judge Quattlebaum's line of questioning. I was just going to ask for a clarification. I understood your brief to make two different arguments about how retaliation is part of this statute. One was directly through the inclusion of discrimination in 1557. And another alternative was because 1557 incorporates the grounds in all these other statutes. What we're talking about right now seems to me to go to the first question. When Congress referred to discriminate in 1557, does 1558 tell us that that didn't include retaliation because retaliation is talked about elsewhere? Does it have any effect on your second argument that 1557 incorporates all the grounds that are prohibited by these other statutory schemes, and some of those include retaliation?
I don't think that 1558 affects that second argument, and the textual basis for that is that Section 1557 is incorporating the grounds of discrimination of those underlying statutes, and what we know about those underlying statutes is the grounds of discrimination include retaliation.
Yeah, and that, which was my question that I
Sorry.
probably asked inartfully, is whether there would be a difference in this section, as Judge Rushing just talked about, where it does incorporate specific statutes that include retaliation. It seems to me that's your best argument, because if they, rather than cited those statutes, they used the status categories of race, age, et cetera, I think you'd have the Nassar would loom larger. Maybe it applies either way, but, I mean, does that make sense?
Accepting that we are disagreeing about which side of which way Nassar cuts, again, I think Nassar is strong authority for us, I just want to note that, but accepting that, I do think that the statutory incorporation of the grounds of prohibited discrimination, you don't even have to get into any of this.
For me.
All right, thank you very much.
Thank you for the extra time.
Mr. Walkinshaw.
Good afternoon. May it please the court, Paul Walkinshaw for the defendants. The district court's decision below dismissing the complaint was absolutely correct, and we believe it should be affirmed. We are dealing here with a complaint that is 21 pages long, that is mostly incongruent, speculative, conclusory, and implausible. And the district court was correct in making those determinations with respect to the discrimination claim alleged under the ACA and the rehabilitation claim alleged under the ACA. We also believe the district court was correct in finding that the novel theory espoused with respect to retaliation was just that, novel, and has not been countenanced by any court before we arrived here today. So we ask that you affirm. On to the decision with respect to the discrimination claim. I've been over this complaint time and time again, and I could not agree more with the district court that there was really only one factual allegation related to discrimination, and that is Dr. Mears' alleged statement that she does not treat veterans or blacks. That is the only concrete factual allegation.
So what?
Enough.
That is not enough because that statement allegedly occurred. First of all, we're not sure when it occurred. And second of all, she doesn't link it up with any affirmative action by.
But that's not what the district court did. The district court said one isolated incident isn't enough. In fact, the district court challenged your assessment that it happened after the termination. It said that was unclear. And the amended complaint makes it clear that it happened before. So I think the question is, if someone makes a direct statement, they're not going to treat you because you're black, how could that be anything other than the most clear case of racial discrimination you could have?
Where is the allegation that Dr. Muir did not treat her? I don't, it's not.
She was discharged as a patient.
The discharge, and I agree with you there, but I think it's important here to distinguish between
Right.
her allegation.
We're here at motion to dismiss, not summary judgment, which I think makes a significant difference.
I agree, but I think it's important to, based on her allegations alone, to distinguish between her allegation that her preterm contractions weren't treated, which is what happened in August, and her dismissal, which she claims she was notified of in September, but actually was dated August 31. The dismissal, Ms. Lucas alleges time and time again, was really not discriminatory. It was retaliatory. And that's why we're talking about retaliation so much, is because her entire complaint, I could cite every page of the complaint, mentions retaliation. And that's what the district court found, is that her dismissal claim is primarily one for retaliation.
So you're saying, I think, if I can just intervene to make sure I'm understanding it, that she was treated, she may have complaints about her treatment, but she was treated, the statement, she was terminated perhaps based on her complaints, and perhaps, what do we make of the statement, at least that the doctor made, that we're not going to treat you anymore, you're going to be terminated as a patient, because of your race?
Well, she didn't say we are dismissing you from the practice because of your race. What Ms. Lucas has alleged is that she was dismissed from the practice because she reported that she witnessed the phlebotomist incident, which she mentions in the complaint, and reported that she was discriminated against. And it was that report that caused her to be dismissed from the practice. So there is no link up plausibly alleged, in my view, between Dr. Muir's statement and the dismissal from the practice, which does render it a lone stray remark. Moreover, there is no allegation in the complaint as to what Dr. Muir did to treat her or not treat her, other than, I shouldn't say other than this one comment attributed to Dr. Muir. We don't know what Dr. Muir did or did not do for her, because it is simply not alleged. So there is no link up between Dr. Muir saying.
If she says, I won't treat you because of your race, what else? I'm not quite sure what else you think there would need to be there.
I would think there would need to be some evidence that that there were encounters with Dr. Muir in the August time period regarding her preterm contractions, in which Dr. Muir refused to treat her. But that is not alleged. We have no allegations relating to that whatsoever, which again, I think is why we are talking about retaliation so much, because as Ms. Lucas admitted herself below, her claim is really one for retaliation, not discrimination. I'll touch briefly.
To be fair, she said she's been focused on that, right? She didn't disclaim the race discrimination claim, and she's pro se, right? This was in court. She's trying to explain her claims, and she says, well, my focus is on one of them. Are you actually arguing that she waived any race discrimination claim because of that?
The district court didn't find that she waived the discrimination claim, but I think that this court could find, based on some of those comments, and the way that her complaint is structured, that yes, she likely has. She
Are we
may,
supposed to give a generous construction to a pro se complaint?
of the pleadings, for sure. The courts typically will give a liberal construction for pro se plaintiffs, but that does not mean that you have to give it a creative construction or a creationist construction, if you will. And the courts are still bound by what's alleged in the complaint, despite the liberal standard granted to pro se plaintiffs.
Let me make sure I understand. Is one of your arguments that we can find as a matter of law from our reading of the transcript that the plaintiff abandoned the race and disability claims?
Well, I think it was knowing and intelligent, which is, I think, what needs to be found in order to make that determination. Ms. Lucas put together a 20-page complaint and seemed to understand many of the legal arguments that were being made below. And she certainly understood the timing aspect, which is how I believe all of this came up, because we were arguing the statute of limitations, I believe, at that point in time. And I think Ms. Lucas clearly understood that she was alleging some acts of discrimination that occurred in August, before August 25 of 2018. And it was in that context that she said that the discrimination, her statute of limitations on the discrimination ran out. So that's why she focused on retaliation. I think that shows intelligence and knowledge on her part, and was frankly a clever pivot at the pleading stage to focus on retaliation in order to bypass the statute of limitations argument. With respect to the rehabilitation claim, we agree with the district court that, the disability discrimination claim, that, and I believe what, Judge, you said earlier, that her own complaint pleads her out of the disability discrimination claim. And that is because she alleges that the reason for her dismissal was not solely because of her disability, but rather A, for lack of trust, and then also B, at page JA 20, paragraph 22 of her complaint, she says, she alleges that Dr. Meir informed her she is being dismissed because she said she did not have time to find another doctor in her high-risk pregnancy in her first trimester. Those are two independent reasons for her dismissal, independent of her disability, that completely supports the district court's finding below that she did not adequately plead disability discrimination. Turning to the retaliation aspect of this case, I wish I could persuade this court to adopt Justice Thomas's dissent in Jackson and his dissent in Gomez, which came a few years after Jackson, in which he lays out, I believe, all of the arguments, many of the arguments that we are having today. One of them in particular.
Sometimes it takes a long time before Justice Thomas's dissents become the majority, but be that as it may.
That is correct. Justice Thomas lays out many of the arguments that we're having here today. One of them is that when it comes to a spending clause statute like we have here at the ACA, that...
I don't mean to sidetrack you, but we really don't need to, I think, engage in whether Justice Thomas, whatever you think about that, is right if we're dealing with Supreme Court contrary to decisions that are contrary. So focusing on Supreme Court majority opinions, what's your argument, to this? You heard my questioning with your colleagues there that, Nassar may suggest in some circumstances, the specific inclusion of retaliation may indicate that it isn't covered by anti-discrimination questions. But here, this statute in 1557 says that an individual shall not, on the ground prohibited under, and it begins with Title VI of the Civil Rights Act. And isn't it true that under Title VI of the Civil Rights Act, retaliation is covered?
Yes, Your Honor.
So we could, in effect, read on the grounds prohibited by Title VI to be on the grounds prohibited by Title VI, which include retaliation? I mean, if we just follow what Title VI means based on the law?
I don't think that it would be appropriate here for the reason that Congress obviously had retaliation on its mind when it passed the ACA. These provisions were passed into law on the same day. They were both part of the same statute. And as Justice Thomas in the dissent and then also the majority in those cases, particularly Gomez, pointed out, the Latin term for the canon I will seriously butcher, but it is the different terms canon. And that is when Congress has enacted a specific provision in the law that differs from another part of the provision, you assume that Congress did so intentionally. And what we have here, what we would have if we were to adopt...
So is that argument that by enacting 1558, Congress in effect deleted what it had written there between the commas in 1557?
What it did was carve out a specific process for retaliation. It indicated that it was thinking about the retaliation claim, which all of the case law suggests is a discrete, it's a different cause of action from discrimination. And they provided a mechanism for retaliation claims, for redress of those retaliation claims. I would say that if we were to adopt the government's position and the appellant's position that 1558 is simply a whistleblower provision and has no impact, then while at the same time agreeing that 1557, because it says discrimination, encompasses retaliation, then we're left wondering why enact 1558?
Well,
because it would be
I don't
superfluous.
think that's what the government is saying completely, or Ms. Lucas is saying completely. I think they're saying that's one of their arguments, that the discrimination includes retaliation. And I think, your point, Nassar may help you there. But they're also saying that that's not what 1557 is limited to. It says also you shall not, it talks about an individual shall not on the grounds prohibited by those specific statutes. So I'm trying to figure out how that works. If you have, if it's expressly incorporating statutes that by law include retaliation, how do we look past that?
Well, I would have two responses to that. One is that it's incorporating the discrimination framework and the definitions of those other statutes. I would argue that it is not incorporating the causes of, all causes of action laid out in those statutes. The second is...
But it talks about, at the bottom, the enforcement mechanisms too, right?
It does. It does. It does say that. But there's an enforcement mechanism in 1558 as well.
Right.
So, I mean, Congress clearly considered, and Congress knew in the background of all of this case law that retaliation claims are separate and can be distinct from discrimination, even though they can also be included in the word discrimination. But why go ahead and pass a separate provision for retaliation if rights protecting retaliation are already protected by 1557, which we have
One reason
to.
is that it includes whistleblower protection, in addition to direct retaliation. One reason is that it's amending the FLSA, and it may do some work in the FLSA, even if it doesn't separately. So, I thought about, a superfluous argument, but it seems like the breadth of it would do more than just direct retaliation.
Well, I'm not sure why they would carve out just for employees, especially if under their definitional arguments, employees would already have protection by being able to file a lawsuit. I hear your point that there is a whistleblower step before they can file a lawsuit, but 1558 still authorizes them to file a lawsuit if the secretary doesn't take any action. So if there are no further questions, we would ask that, anything further?
Thank you very much.
We ask that you affirm. Thank you.
All right. Mr. Wolfman, you have a little bit of rebuttal time left.
Thank you, Your Honor. I will be brief, and I'll just begin by saying if the court has anything further on the retaliation questions, I'm happy to answer, but otherwise, I'm satisfied with what we've presented. I do want to say just a couple points on the notion that these claims of discrimination were abandoned. In addition to the reference to my client being pro se, she said that at the hearing she was primarily focused on retaliation. She did not abandon the claim. And this court's decision in Airfax makes very clear that you have to be explicit and precise and absolute if you're abandoning a claim at a hearing. Otherwise, as Airfax says, you rest on the complaint. And as I said, our complaint is more than sufficient. As to the disability discrimination specifically, opposing counsel simply said that, well, there's an alternative basis that is other than discrimination. It is a lack of trust. But that's drawing inferences in the non-moving parties, in the moving party's favor. We don't, of course, concede that lack of trust was the real reason. We believe it was a pretext for discrimination. And again, that will be rolled out later at summary judgment, or we believe at trial. Unless the court has anything further, we just urge the court to reverse on all claims. Thank you.
All right, thank you very much. We'll come down and greet counsel, but first I'd ask the clerk to adjourn court for the day.